Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And for today's stream, I wanted to do a historical Supreme Court React. So you will know the series that we do from time to time where we respond to oral arguments of the U.S. Supreme Court. And I thought we'd go back in time and do a historical one because that sounded fun. So we're going to go back to 1966, my friends. In the case of In re Gault is our case for today. Gerald Gault is 15 years old in 1966, and he places a phone call. And someone says that he was obscene in the phone call. He said some things that were obscene, legally obscene, okay, as a 15-year-old. All right, so the police decide to investigate this crime, and they arrest Gault, the 15-year-old, for the obscene phone call. The police, when they arrest Gault, do not leave notice with Gault's parents, who are at work when the person was committed. The trial of Gault was a hearing before a judge, before a juvenile court. The hearing consisted of Gault being present, not even the person who accused him. All right. So the hearing was Gault in a room by himself, not even the person who accused him, and the judge just found him guilty. Okay. They just found him guilty at 15. He then proceeded to sentence Gault to 6 years in juvenile facility to be held as an incorrigible youth until the age of 21 for this phone call. So you can see the problem, right? The kid is arrested for the obscene phone call. His parents aren't notified. He is tried in the form of, how about you go before a judge? Your parents aren't allowed in the room. You're not allowed a lawyer. The person who's accusing you isn't even in the room. And the judge just finds you guilty and sentences you to 6 years in juvie for the obscene call. Okay. That's what happened in 1966. In Arizona, to be specific. All right. So the question before the United States Supreme Court is this cool? Oh, by the way, just by the way of noting this, because I think it's interesting. Had an adult done this exact same thing, the maximum possible penalty would have been 6 months. So if an adult had done this obscene phone call, 6 months. For the 15-year-old, how about 6 years with no lawyer, no right to confront your witnesses, no parents in the room, no. How about we just find you guilty? Okay. So the question before the United States Supreme Court is this constitutional? Because Arizona's like, yep, we don't see any problem. The Arizona Supreme Court's like, this is totally fine. We don't see any problem with this. We can arrest the juvenile, the 15-year-old, and charge him with things and not let him confront his accuser and not let him have an attorney. And, we can just find him guilty and sentence him to 6 years. The Arizona Supreme Court's like, this is totally, totally cool. Not a problem. We don't see the issue. So the issue is, was this process constitutionally legitimate under the due process clause? Or I suppose even more to the point, are people under the age of 21 at the time, because, the constitutional amendment to lower the voting age to 18 hasn't happened yet. So are people under the 21, does the Constitution protect them too? Does it protect them too? So does the Constitution apply to the under 21-year-olds? Is the question in 1966. So then the case is decided in 1977. So we're going to listen to this oral argument from 1977 and see what the Supreme Court has to say about the issue about, is it okay that we charge the kid and not let him confront his accuser and not let him have an attorney and not tell his parents about it and sentence him to 6 years? Is that cool? All right. So let's go ahead and get started with this.
Number 116, in the matter of application of Paul L. Gault et al., Appellants. First.
Chief Justice Warren is presiding. Be your man in the middle there.
Mr. Dorson,
Before proceeding to the argument, Mr. Chief Justice and members of the court, I would like to move the admission of the Assistant Attorney General of Arizona, pro haec vice, Frank A. Park.
Mark may be admitted for that purpose.
Application of Gault number 116. This case raises important constitutional questions concerning the extent to which requirements of procedural fairness guaranteed by the Due Process Clause of the 14th Amendment are applicable to juvenile proceedings. Appellants, the parents of Gerald Francis Gault, claim in particular that the Arizona Juvenile Code, on its face and as applied in this case, is invalid in failing to provide the following basic protections: the right to effective assistance of counsel, the right to adequate notice of the charges of delinquency, including time to prepare, the right to confront and cross-examine the complainant, the privilege against self-incrimination, and the right to a transcript and meaningful judicial review. These issues, which were duly raised and passed on below, will be taken up severally in due course. In this case, Gerald Gault, at age 15, was committed for the period of his minority, that is, for up to 6 years, to the State Industrial School in Arizona, after a juvenile delinquency proceeding consisting of 2 hearings in the Superior Court of Gila County, Arizona.
Remember, at this period of time, adulthood wasn't until 21. So he's 15 and he's going to be held in juvie until he's an adult, which is 21 years old in 1966. So, yeah. So good times.
This appeal is from a decision of the Supreme Court of Arizona in a collateral action. That court affirmed a decision of the Maricopa County Superior Court, which, after a hearing, dismissed the petition for habeas corpus filed on Gerald's behalf by his parents, Paul and Marjorie Gault. Gerald is still in confinement and has been for 2.5 years. The facts are relatively simple, and yet it is not possible to be confident about exactly what happened at the original proceedings. The reason is that although there were 2 hearings leading to the determination of Gerald's delinquency and his commitment, a transcript was not made of either one.
So you can see how well this is going in 1966, right? So the guy who's advocating for Gault is like, yeah, the facts we think are simple, but we're not actually sure because there was no transcript of this hearing. That's how well it's going in 1966. This 15-year-old is being hauled before a court, no right to confront witnesses, no right to remain silent, no right to an attorney, no right to have his parents present, no right to anything, and is determined to be a delinquent. And we have no transcript of any of this. It's going really, really great in 1966. So it's like, well, here's what we think happened. So, okay, let's press on.
The facts, accordingly, are based on the habeas corpus proceeding in the Maricopa County Superior Court. At that hearing, it appeared without dispute that on the morning of June 8, 1964, Gerald Gault and a friend, Ronald Lewis, were taken into custody by the Sheriff's Office of Gila County as the result of a complaint by one Mrs. Cook, a neighbor of the boys, about an allegedly lewd telephone call. Gerald at this time was on 6 months probation following an incident in February 1964. At that time, he was with another boy who was alleged to have taken a wallet. The other boy was confined, and Gerald was put on probation. After Mrs. Cook's complaint, the boys were taken to the local probation office pursuant to the Arizona Code. The probation officers, Flagg and Henderson, who have the authority of peace officers in Arizona, decided to detain the boys for a delinquency hearing, and Flagg interrogated Gerald at some length during the evening of June 8th and the morning of June 9th. No notice of the detention or charges was left at the Gault home. Mrs. Gault, who returned from work at 6 p.m. on that day, June 8th, was informed by her older son, through neighbors, that Gerald was detained, and she then went to the detention home. There she was told by probation officer Flagg, quote, of the general nature of the charges, unquote, and that a hearing would be held the following day, June 9th.
So you can see how fast this is going in 1966, right? This starts on June the 8th, okay? On June the 8th, a woman says, hey, this kid made a phone call that's obscene. And it's like, how about we have a hearing the very next day? The very next day. Mom shows up, not being told by the police where her son is, having been informed by a neighbor that the police came and arrested him, or by their older son, their older child that the son is coming. It's like, okay, no problem. There's going to be a hearing tomorrow about this. Great. It's going great over here in 1966. Well, a little bit of a rush to judgment over that. Let's press on.
No written notice of this hearing or of the charges was given to Mrs. Gault at any time. On June 9, a petition charging Gerald with being a delinquent minor was filed by Probation Officer Flagg with the Juvenile Court. This is on page 80 of the record, the petition. This petition was filed pursuant to the Arizona Juvenile Code. In the Arizona Juvenile Code, a delinquent child is defined in section 8-2016 in the appellant's brief on page 3A. Mrs. Gault did not receive notice of the petition and did not see it until August 17, when the habeas corpus hearing was held in Maricopa County. A juvenile referral report, an internal juvenile court document prepared by the probation office for the court, charged Gerald with making lewd phone calls. This was prepared when Gerald was taken into custody on June 8, was completed after the hearings, and filed with the juvenile court on June 15. It, too, was not brought to appellant's notice until the habeas corpus hearing on August 17.
So this whole thing starts on June 8th, and by August 17th, we're already talking about habeas petitions. So things are moving rapidly over here in Arizona. So we're taking our right to due process really, really seriously, I guess. On June 8th, we're like, how about arresting you? And on August the 17th, we're already talking about a habeas petition. So it's like, okay, well, that's been a quick 2 months. So that's how fast that's going. All right.
Could you emphasize the fact that no notice was given to Mrs. Gault? Why would she be the one, if you're right in your theory?
Well, the suggestion has been made, Mr. Justice Stewart, that notice was given to Mrs. Gault. It is plain from the record that no notice at any time was given to anyone else in the family of Gault, and therefore I want to emphasize the extent to which the facts show any notice of any kind to any member in the family.
To anybody.
Right.
Well, how about the juvenile?
The juvenile received no notice whatsoever, as far as the record shows. There was discussion with the juvenile orally, and he may have known the general tenor of the charges, but the only notice that was given that was discussed in the record and discussed by the Supreme Court of Arizona was the oral notice given to Mrs. Gault on the evening of June 8th. On June 9th, the initial hearing took place in Judge McGee's chambers. He was the juvenile judge. Present were Gerald, his mother, his older brother Louis, and Mr. Flagg and Mr. Henderson, the probation officers. No one was sworn, no transcript was made, and neither Gerald nor Mrs. Gault was represented by counsel or advised of any right to counsel. With respect to Gerald's conduct that led to a finding of juvenile...
Why would we swear anyone in on a hearing to determine whether or not someone should be locked up for 6 years? Why would we? And this whole thing is happening in the judge's chambers. It's not even happening in open court. That's how well it's going in 1966. How about we just do it in my chambers? Swearing in witnesses, why would we bother with that? Okay, it's going super well.
Juvenile delinquency, there was conflict at the habeas corpus hearing. As stated in the opinion of the Arizona Supreme Court at page 84 of the record, quote, there was a conflict in the testimony at the habeas corpus hearing concerning what transpired at the juvenile hearing. Mrs. Gault testified that in response to the judge's questions at the juvenile hearing, Gerald said he dialed Mrs. C's number, asked her if it was such and such a number, said there was a friend of his who wanted to talk to her, then handed the phone to Ronald, who made the lewd remarks. There on page 79, Mr. Justice Harlan, in the referral report. Officer Flagg testified that at the juvenile hearing, Gerald admitted making the phone call and using some of the obscene language. Judge McGee testified that Gerald admitted using some lewd words. Following the hearing on June 9th, Judge McGee continued the case until June 15 because, in his words, I didn't know myself what I was going to do because I was not satisfied from the testimony there at that time. Accordingly, Officer Flagg did some more investigating until the 11th. He testified, "I talked to Jerry Moore to see if he would tell me any more. I talked to Ronnie Lewis some more, looking for a change of stories, perhaps." Gerald was returned home on June 11th or 12th. On that day, Mrs. Gault received a note on plain white paper from Officer Flagg, which said, quote, "Mrs. Gault, Judge McGee has set Monday, June 15th, 1964 at 11 a.m. as the day and time for further hearings on Gerald's delinquency. Signed, Flagg." This was the only written notice of any kind that any member of the Gault family received concerning this matter prior to the determination of delinquency and the commitment of Gerald to the industrial school.
So that's on June the 15th, right? So the initial arrest occurs on June the 8th. June the 9th, we have some sort of initial hearing in the judge's chamber. And June the 15th, we essentially convict the guy. This whole thing happened within the space of a week. And there's no attorney involved. There's, it's just how this whole thing is just happening inside of a week. So yeah, the Arizona Supreme Court saw no problem with any of this. All right.
On June 15th, the second hearing was held. It was held in the presence of Gerald and both his parents, Officer Flagg and Ronald Lewis, the other boy involved in the incident, and Ronald's father. Again, neither Gerald nor his parents was represented by counsel. At the habeas corpus hearing on August 17th, there also was conflict about what happened at the juvenile court hearing of June 15th. Again, in the words of the Supreme Court of Arizona, quote, "There was a further conflict in the evidence at the habeas corpus hearing concerning the testimony at the second juvenile hearing. Both Mr. and Mrs. Gault testified that no one accused Gerald of making a lewd telephone call, and also said that Gerald admitted nothing. But Judge McGee said Gerald admitted making some of the lewd remarks, although not the more serious ones. At this hearing, Flagg supported the Gault's version, stating that neither boy admitted making the actual remark. It should be noted that Mrs. Cook, the woman who had complained about the phone call, was not present or called as a witness at either hearing."
So the woman who presumably, is the only witness because it's a phone call, right? So this woman who's like, "Yep, these boys made the obscene phone call." Where's the woman? She's nowhere to be found. The woman who apparently said, "Yeah, these boys made the obscene phone call. I heard it with my very own ears." Where is she? She's not here. She's at none of these hearings. Why would we need to hear the chief witness against the juvenile before we sentence him to 6 years? Why would we need to hear from this woman in open court? Why would we need to do that? Apparently no one thought that was important. So, this witness, nowhere to be found. Not a problem, apparently. Okay, it's going great.
Officer Flagg had talked to her over the telephone on June 9th, and Judge McGee had not spoken to her at all. When Mrs. Gault asked the judge during the hearing of June 15th why Mrs. Cook was not present, saying that, quote, she wanted Mrs. Cook present so she could see which boy that done the talking, the dirty talking over the phone, Judge McGee answered, quote, she didn't have to be present. On June 15th, Judge McGee handed down an order containing no findings of fact.
Why would we need that?
The order simply states that after a full hearing,
the judge made no findings of fact. So what did he say during the phone call? We don't know. We don't know what was said during the phone call because the witness wasn't there. The judge made no findings of fact. Just simply said, yep, this boy's guilty. He's incorrigible. He is a delinquent youth. No findings of fact. Yeah, that's wonderful.
And due deliberation, the court finds that said minor is a delinquent child. The order then says that the child's own good and the best interests of the state require that he be committed to the state industrial school for the period of his minority, unless sooner discharged by due process of law. 15 years old. In his testimony at the habeas corpus hearing, the judge, Judge McGee, indicated that there were several bases for his decision. One was a violation of Section 13-37 of the Arizona Criminal Code, which is contained in our brief on the appendix, first page. This statute makes it a crime to use, quote, vulgar, abusive, or obscene language in the presence of a woman or child. A delinquent child is defined by the Juvenile Code, reproduced at page 3A of Appellant's brief, as including a child who has violated the law of the state, such as the section I have just quoted.
What's the penalty for the commission of that crime by now?
2 months is the maximum penalty plus a fine.
So earlier I said the maximum penalty for an adult was 6 months. I apologize, I misspoke. The maximum penalty for an adult would be 2 months. 2 months for an adult. So, yeah.
And this boy got...
Up to 6 years. Mr.
Seems a little bit problematic.
Judge McGee... Well, I of course have not been there. It's a school where delinquent children are sent. The school is kept under the control of a board of supervisors. The boys who are sent up there are sent up there for various offenses, ranging from theft to a lewd telephone call.
Neglected children also sent there? Neglected juveniles?
No, just delinquent children.
It's a security institution.
I believe it is. Yes, Mr. Chief Justice.
Boy can't go home.
Can't go home. That's pretty clear. He can't go home until his minority, unless the board of governors of the state industrial schools let him go home. The boy is in the exclusive control of this board.
And his parents are deprived of it.
That's absolutely right, Mr. Justice.
Did this boy have any record other than this purse business which he was
He had
present?
no record of any kind except for the purse allegation that I've mentioned, except for the fact that the juvenile judge did mention at the time that he reached a decision, as I was just about to mention, that there was an earlier incident in 1962 having to do with a baseball glove that someone had suggested that Gerald had stolen. But there was no hearing on this, and the case was dropped because there was no material foundation for the claim.
Is there anything other than the judge's statement on that?
That's correct. There was nothing else beside the judge's statement. There was nothing in the record on that. Judge McGee testified at the habeas corpus hearing that at no time did he ever advise Gerald's parents that he was charged with violating this statute. Another ground, the second ground on which
he wasn't
the judge...
charged with violating that statute, was he?
He was charged with being a delinquent because he violated that statute. That was the first ground that the judge stated. The second ground on which the judge considered the boy delinquent was that he was, quote, habitually involved in immoral matters. And in this he was referring to subsection D of section 2016 of the Juvenile Code. The exact language of subsection D, which is on page 3 of the appendix, is, quote, a child who habitually so deports himself as to injure or endanger the morals or health of himself or others. Judge McGee also testified at the habeas corpus hearing that there was, quote, probably another ground too. In connection with the ground of habitually involved in immoral matters, the first mention of which was at the habeas corpus hearing, the judge said that he took account of an earlier allegation that Gerald had stolen a baseball glove from another boy and lied about it to the police. This allegation was contained in a probation office referral report, but the incident was never made the subject of charges in juvenile court, and no hearing was held, according to Judge McGee, because of lack of material foundation.
Is that in this record?
It is not in this record. Judge McGee testified to this, but it is not in this record, Mr. Justice.
Is that what the judge referred to as habitually...
That's right.
Habitually being
That was one of
involved
the
in
things.
immoral matters?
He mentioned this fact, Mr. Chief
There was
Justice.
nothing
in the record.
comparable to what happened in the instant case.
That's
in
right.
The record, was there?
That's correct. It is undisputed that the questioning and answers of Gerald by the court at the two hearings led to his adjudication as a delinquent and his commitment. Judge McGee testified as follows at the habeas corpus proceeding. Question: were any adult witnesses sworn and or heard against the boy Gerald Gault? Answer: no. It was all in my mind, done upon the admissions of Gerald Gault. and at no point was Gerald informed of a right to remain silent.
Yeah, that's
Whose
good.
testimony is that?
That's the judge's testimony, Judge McGee. After the habeas corpus hearing, the Maricopa County Superior Court dismissed the petition, discharged the writ, and remanded Gerald to the State Industrial School. The Superior Court did not write an opinion. On appeal from this decision, the Supreme Court of Arizona affirmed. In an extensive opinion, starting at page 83 of the record, it dealt with each of the constitutional claims that are the subject of this appeal. The court held as follows. First, regarding notice of charges, the court ruled that young Gault received adequate notice because, quote, Mrs. Gault knew the exact nature of the charge against Gerald Gault, from the day he was taken to the detention home.
Right there, Mr. Dawson.
Sir.
Should I read the Supreme Court opinion as saying its view is that that notice constitutionally is required?
I believe so. I believe so.
So the issue on notice here is only as to its sufficiency, is that it?
Well, our position is that there was no adequate notice at all because there was
but
no...
I mean, the issue here is not... Is there an issue before us whether constitutionally it's required or only on the adequacy of the notice?
Well, whether it's constitutionally required and the adequacy, it seems to me.
Although we start with the premise the Supreme Court of Arizona agrees that a notice is constitutionally required.
Well, that's right, and that's true. The court also
Did the
stated...
Supreme Court of Arizona hold that, or did it hold that, assuming notice is required, notice was given here?
Well, the exact language is at the bottom of page 94 of the record and the top of page 95. We find that petitioners were not denied due process of law. And the court goes on to say, Mrs. Gault knew the exact nature of the charge against Gerald from the day he was taken to the detention home.
So that would seem to imply that the court thought that notice was a part
Yes,
of
Mr. Justice.
their due process.
The court also stated, with respect to notice, the following rule that would govern in the future, that the infant and his parent or guardian will receive a petition only reciting a conclusion of delinquency, but no later than the initial hearing by the judge. They must be advised of the facts involved in the case. If the charges are denied, they must be given a reasonable period of time to prepare. That's at 92 in the record. Second, with respect to the right of counsel, the court below held, although parents cannot be denied representation by retained counsel, due process does not require that an infant have a right to counsel. The court held further that Gerald was not denied due process because his parents, quote, knew they could have retained counsel.
Because someone asked me in chat, by the way, I thought I've been looking in the background to see if I could answer the question as to what exactly was alleged that this person said, and there doesn't seem to be any record of it at all. I went to the National Archives in the background. I went to the National Archives in the background, and I pulled the original Amicus. I pulled the original brief to the Supreme Court, and it doesn't appear to discuss it. The original brief to the Supreme Court doesn't appear to discuss what this kid apparently said, just that it was lewd and obscene. So there doesn't seem to be any record about exactly what this kid said that I can find. It's not in the court's opinion that I can find. It's not in the brief to the Supreme Court. Apparently no one thought it was important what the exact words of the kid said. Apparently that was not an important factor. Okay. So yeah, it continues to go that well over here. So yeah.
The court also said that the parents and the probation officer may be relied upon to protect the infant's interests. Third, with respect to confrontation and cross-examination, the court below held there was no denial of due process because the relevancy of confrontation only arises where the charges are denied. The court stated that the parents knew they could have called witnesses and cross-examined probation officer Flagg. Yes, he was, as far as I know, though I do not believe that the records show he was a regular member of the Superior Court of Arizona. Sitting in his juvenile capacity pursuant to the Juvenile Code.
There's no independent juvenile court in Arizona?
No, there is not. It's a section of the Superior Court, and sometimes the cases are sent to referees. With respect to the privilege against self-incrimination, the court below noted the division of authority in state courts over whether an infant has a privilege against self-incrimination or a right to be advised of the privilege. The court then held that the necessary flexibility for individualized treatment will be enhanced by a rule which does not require the judge to advise the infant of a privilege against self-incrimination. Fifth and finally, with respect to the right of transcript and appellate review, the court held that there is no right of appeal from a juvenile court order and that there is no right to a transcript. The court said that the juvenile court has discretion
Thank you, Tony,
to
for
order
the super
or
chat.
deny the taking of a transcript. It is the position of appellants that Gerald Gault was deprived of his liberty without due process of law in the juvenile court of Keeler County and that the judgment of the court below should be reversed. Before proceeding to these constitutional questions severally, it may be helpful if I very briefly outline some of the background of the juvenile court problem. Prior to the juvenile court movement, which started in Illinois in 1899, juveniles were treated like all other criminals, at least all other criminal defendants. Except for capacity, problems of mens rea, they were subject to the criminal law and they received the existing safeguards.
What is the rule in Arizona, if you know, Professor Dorson, as to the age of competency?
I don't know. I believe it was the common law rule of 7, but I'm not certain of that. Is that correct, Mr. Park? The juvenile court movement was a response to findings of social science, psychology, social welfare, and to new theories of rehabilitation that flourished at the turn of the century. Accordingly, juvenile courts were established beginning in 1899, and now we find them in every state of the Union. The proceedings in these juvenile courts are civil, not criminal. The court is theoretically engaged in determining the needs of the child and of society rather than adjudicating guilt and meting out punishment. The court and the state are acting as parents patriae rather than prosecutors or judge, treating the child as with a firm but benevolent parent. But parents patriae and individualized justice led to proceedings in juvenile court that dispensed with certain traditional rights. In some states, courts have ruled that juveniles are not entitled to bail, to indictment, to speedy and public trial, to confrontation of accusers, to the privilege against self-incrimination, and the right to counsel.
So see, like, this is a systemic problem at this point. This is one of the reasons I'm covering this case, is because this is a case, obviously, that changes this, right? At this point in history, in 1966, Arizona is not alone on this, right? Arizona is not alone. Many states at this time say, juveniles, you're not entitled to due process. You're not entitled to bail, indictment, speedy public trial, confronting accusers, privilege of self-incrimination, right of counsel, none of that stuff. So, like, the Constitution just doesn't apply to legal infants, which, by the way, is anyone under the age of 21, right, at this time in history. So, yeah, this is a case that's pretty seminal. It's pretty important. It's like, hey, maybe the Constitution applies to the under 21-year-olds too. Maybe when the 14th Amendment talks about all persons born or natural and born and naturalized in the United States or citizens of the United States, maybe all people born includes the 14-year-olds or the 15-year-olds or the 19-year-olds or the 20-year-olds at this point in history. So it's just interesting to see how much things have changed, right? At this point in history, we can just the state is acting as parent patriae. They're acting instead of parents, and they can do anything a parent can do. And does a parent need to act with due process to their own child? Not in particular, not really. So that's like, okay, I'm the parent now, says the court, and I can do anything a parent can do, including sending you to school for the incorrigible youth for the next 6 years. It's not criminal, by the way. It's civil, but you can't leave. So things are a little bit different in 1966. So I think it's really important to note this. Thank you, Kiki Dawn, for 12 months of membership. Yeah, and I continue to look through the record and trying to figure out what this kid said, and all anyone describes it as lewd, which I don't know what the hell that means, and neither do you. That can mean a whole lot of things. And also 1966's view of what lewd means is probably not what 2023's view of lewd means. So it could be something fairly innocuous, at least by modern standards. It's like, hey, woman, you look good in that skirt. Have you considered taking it off? Maybe that's beyond the pale in 1966. I have no idea because there's no record of it. All we know is that, and also, of course, the woman didn't testify at the hearing. So she never testified about what had heard. And even if she had, there was no record of it anyway. There was no transcript. So, who knows what was said, or apparently that was not considered an important detail by this judge. Apparently that was not considered important. Why do we need to hear from the woman who says that the kid said the thing and try to determine whether or not the kid said the thing? The kid admitted to making a phone call. That's good enough for me. Yeah.
But of late there has been increasing criticism by scholars and re-examination by courts. Questions have arisen as to the fulfillment of the original goals of juvenile court movements, and especially about the barter of alleged special treatment for constitutional protection. The climax came last year in Kent v. United States. Summing up the present situation, the court said as follows: while there can be no doubt of the original laudable purpose of juvenile courts, studies and critiques in recent years raise serious questions as to whether actual performance measures well enough against theoretical purpose to make tolerable the immunity of the process from the reach of constitutional guarantees applicable to adults. There is evidence, in fact, that there may be grounds for concern that the child receives the worst of both worlds, that he gets neither the protections accorded to adults nor the solicitous care and regenerative treatment postulated for children.
Kent was not a constitutional decision.
That's correct, Mr. Justice Douglas, and I was in Kent, the court did not decide these questions, but they were specific. The court specifically reserved them, and specifically reserved the question whether constitutional guarantees which would be applicable to adults must be applied in juvenile court proceedings.
Also, it's just like cool how many like total badasses are on the court at this period of time. Like Potter Stewart, Hugo Black, William Douglas. I mean, just like these names from Abe Fortas, right? I mean, these names have been a little bit lost to history, but William Brennan is still on the court in 1966. That's like, holy shit, dude. I mean, these are some heavyweights, right? I mean, these are some heavyweights in this court in 1966. So I think that's really cool too. You see these names from history. You see these pictures from history. I think that's wicked cool.
This case presents that issue in the 5 specific respects I've outlined above.
How long has this Arizona statute been on the books?
I'm not certain. I think it was amended in 1962, but I'm not sure of the exact date of enactment, Justice. Many of them do. Many of them do, and in safeguards specifically, some of them provide by statute and some provide by court rule. For example, I was about to turn to the question of right to counsel, and according to the the National Legal Aid and Advisors Brief, 78% of the jurisdictions in which legal aid operate provide a right to counsel.
Well, doesn't New York have almost a complete panoply by
That's correct.
By legislation?
Under the recent Family Court Act, New York has provided for appointed law guardians, as they're called, and they are specifically enjoined with the responsibility of representing the children's interests.
You keep a record also?
Record is kept. The standards of that have been promulgated jointly by the National Council of Crime and Delinquency, by the National Council of Juvenile Court Judges, and by the Children's Bureau of the Department of Health, Education, and Welfare also provide for these safeguards.
Mr. Dorson, Professor Dorson, have you seen a theoretical articulation of the basis for reading the Constitution of the United States so as to carve out juveniles? What is the theoretical basis?
I have seen some, Mr. Justice Fortas, and we submit that these are insufficient. The justifications are several. One is the justification of the therapeutic aim or the individualized justice that is to be accorded juveniles. But of course, in this case, we are not saying anything about what treatment juveniles should receive once they are determined.
Suppose a state passed a statute applicable to adults, which tracked all of this, and the state declared that now the state is parens patriae of adults, and nobody's going to be sent to jail. They're just going to be sent to industrial homes, and there they will be well fed, well shod, well clothed, but they can't get out. Now, how would one dispose of that and distinguish that from the case of children? I suppose we'd all agree out of hand that there's no excuse for depriving people of constitutional guarantees. Now, what is the basis for distinguishing between that and the case of juveniles? The Arizona statute goes up to age 21, doesn't
Age
it?
18.
18.
There are statutes. California, for example, goes up to age 21.
All right, 18. Now, what is the basis for saying that an 18-year-old boy can be deprived of constitutional guarantee on the parents' patriae theory, but that the state couldn't go through the parents' patriae formula and deprive adults of constitutional guarantees?
Well, I have seen no satisfactory explanation.
Well, what about this one, Mr. Dorsey? I know there's one of the briefs here.
By the way, I'm thinking about doing this as more of a ongoing thing depending on interest. So obviously I did this sort of on a lark and without particular announcement. So I'll be interested to see how this video does over time, and interested to see how people react to it and sort of whether or not people want to see this, because I have a thought in my mind about like going to try to hit basically every big case since they started audio recording, which I think was sometime around the 1950s. Be interesting. And maybe just like hitting like every Supreme Court case basically for the last, 70 years at this point. Could be kind of cool. So depending on people's interest and depending on people's reception about it, we might do that. We might try to see if we can hit, at least all the big cases. We'll try to hit like maybe big 5 or 6 big cases every year for the last 70 years. So, just 350 episodes of channel left to go there. So, hey, maybe. We'll see how people respond to it, though. It's going to be based on people's interests, so we'll see.
Suggests that fundamentally, speaking now in legal concept, the basic right of a juvenile is not the liberty, but the custody.
We reject that.
I know you reject it, but doesn't that sum up the legal concept upon which some of these rights are denied?
I think it may. If I understood exactly what it meant, I could be sure.
Well,
obviously,
it seems
thank
to
you,
me
Contrarian, for the gift membership.
This brief suggests in any event that it means that there are special problems with the child's best interest, which, building on the notion that the basic right of the juvenile is custody, whether he's a juvenile delinquent or not, the children of all of us are supposed to be in custody of the parents, and that's the notion that supports this different treatment. Isn't that supposed to be it?
Well, I think that argument might well be it, Mr. Justice Brennan.
No, but isn't that the argument?
Well, I must confess, it may well be. I do not understand it, because no matter how many times one says parents patriae, I think there is a small difference.
Don't have to understand it.
But that may well be.
That is the argument.
That is the argument that the Ohio juvenile court judges made.
Sprang from the idea that the state is standing in the shoes of the parents.
That's correct.
Natural parents.
That's correct.
Natural parents no longer that to get beyond humanitarian strictures can control a child. Incessantly. Keep them in their room.
Oh, that's right.
They can stand in the corner. So it's the state then. That's the idea.
I guess that is it. It's of course.
But also, Springs, it also part of it is a quid pro quo. You don't. I suppose at common law, you could take an 8-year-old boy and put him to trial before a jury and convict him and sentence him to be hanged, and give him all the constitutional rights of trial by jury and cross-examination and the rest of it. They decided to remove that from the courts of the criminal courts and set up an alternative procedure.
We'll recess now.
I'm not 100% sure why we're doing this, but apparently in 1966, we take a break at the half-hour mark. So I don't know, but, they take a break, I suppose, in between. So, yeah, we've only a half hour into this. And it's like, okay, it's break time. Okay. Maybe we should bring break time back. Make break time great again. All right.
Mr. Justice, in connection with the question of justification for the procedures in this case, whether considered from the point of view of custody, treatment, therapeutic aim, appellants would like to stress to the Court the very important and, in our view, very sharp distinction between the determination of delinquency and any custodial obligation that the state may take after the child has been determined to be a delinquent. There's no inconsistency, in our view, between having the kind of protections that we're suggesting are required by due process and the finest custodial and treatment processes in the country. Just 2 weeks ago, the Supreme Court of New Jersey unanimously reversed a juvenile's case, a determination of delinquency, and Judge Proctor, in a very careful opinion, said, assuming a juvenile is not entitled to all the constitutional requirements of a criminal trial, we firmly believe he is at least entitled to a fact-finding process which measures up to the essentials of due process and a fair hearing. And in this connection, it might be worth noting that New York, in its recent statute, has specifically provided for two distinct hearings, a determination of delinquency hearing and a disposition hearing. And similar standards are suggested by the Children's Bureau of the Department of Health, Education, and Welfare, the juvenile court judges, and the National Council for Crime and Delinquency.
How far does New York go in recognizing constitutional rights?
Well, New York provides for an appointed right to counsel. They provide for the privilege against self-incrimination. They provide that the facts upon which the delinquency is alleged to have occurred are brought to the attention of the child, and they provide for... In writing? In writing.
They have an open hearing?
Not an open hearing, closed hearing. No jury trial, Mr. Justice White.
Right of review.
A right of review.
Where is
Burden in New York is by preponderance of the evidence. In Arizona, it's by clear and convincing evidence. Confrontation is permitted in New York, required in New York. In fact, they go so far as to say specifically in the statute that a confession made out of court is not admissible as the sole basis for a finding of delinquency.
This lady that had to testify.
Correct. That's correct. In fact, there was an earlier case in 1932, the Lewis case, which was in a sense overruled by the recent changes in New York law.
How do they reconcile not giving full counsel rights, pick and choose like this?
Well, of course, there is a question about that, and for example, to take the example that Mr. Justice White mentioned, there are certain problems of confidentiality that would seem to be applicable in the case of a child, so there might be a justification for keeping such a proceeding.
Sometimes, of course, they have oath on that oath, but it's closed hearing. Exactly. I was just thinking about some of the other things.
Well, of course, those haven't been tested yet.
Where do they go from there?
They go to an appellate court through the New York court system.
Appellate division?
Yeah. No trial de novo, although some states have provided a trial de novo. Not New York. There is a transfer.
What's left of the...
Pardon me?
What is left of the juvenile system as it was conceived under all federal constitutional rights? What we could do?
Well, we would suggest that the best part, namely the opportunity for the state, in a case where a child has been properly determined to be a juvenile, to do what it can to treat him, to take care of him, to rehabilitate him. And we're suggesting that the procedures that...
Could they do that differently to the way they do it for adults?
Well, I think that only in the sense that children are in a more formative stage, and that the theory of child care has been that a child can be brought along in a different way than adults can be.
Confinement, you might distinguish between confinement. It's like in the federal system. It used to be, I'm sure you still do. One penitentiary for prison, another had a medical penitentiary down in Europe it was. I remember they had one they called Clark Country Club in Texas.
I was just looking at like historical cases. Bummer. The audio recording only goes back to the October 1955 term. The reason that's a bummer is that Brown versus Board of Education was argued the previous year, April 1955. Lame. How cool would that be to be able to listen to that oral audio? I mean, there's a transcript of Brown versus Board, but it was argued twice, incidentally. It was argued in 1952 and then 1955. No, it was argued, 1952, 1953, and then 1955. And there's no oral record of it. That sucks. Oh, well.
That is true. Unfortunately, as the system is developed in many states, up to 3/4 of the states, it's still possible for juveniles to be referred to regular prisons in the company of adult criminals. And this is pointed out in the Health, Education, and Welfare Study on page 71.
Mr. Norson, your theory here applies only to the delinquency part of the work of the juvenile court.
That's correct, Mr. Justice Fortas. There are two other sections in the Arizona Code, as there are in several other states, neglect and dependency. The first where the parent is found to be at fault in some way, and the second where there is nobody at fault.
Getting back to the would your position carry you as far as public trial?
Well, of course, that question is not presented here. And therefore, I'm not...
I don't know that we can answer some of the questions you want us to without thinking about some of these others.
I am not urging that position in this case.
Well, how do you distinguish it?
Well, I would distinguish it, apart from the fact that the record doesn't present the question, from the point of view that the child's special sensitivities to publicity, the special stigma that might attach to a child, the child's disorientation before a public.
Or as parents come in to demand a public trial. They have a constitutional right to a public trial.
Thank you, Ellen Parker.
I'm not sure how I would decide that case.
You might have to think about it.
I have thought about it, and I would not now urge the court to take the position that a public...
So Trenton says, apparently, I'm not sure where he's pulling from, that one boy allegedly told Mrs. Cook that his friend wanted to speak to her. The other boy asked her, "Are your cherries ripe today? And do you have big bombers?" Apparently. Was what was said, according to Trenton. Because I can't find it anywhere in the record, so I'm not sure where in the record that is. But apparently the obscene, lewd, 6 years in juvie comments were, "Are your cherries ripe today? And do you have big bombers?" Wow. Sensibilities in 1966 are a little different than they are now, aren't they? Damn.
Trial is required.
Mr. Dorson, how much is left of this confidentiality of the juvenile proceedings? Don't the draft authorities have access to juvenile records?
That's correct.
Does the FBI have access to it? As a matter of fact.
As a matter of fact, the recent Harvard study cited to the fact that the FBI is given all reports of delinquency, or at least a large number of reports.
Do the police authorities in the same jurisdiction have access to it?
As far as I know, they do, even though the Arizona Code purports to protect the juvenile by providing for destruction of all records within after 2 years following his release from confinement.
I've wondered whether all this business about confidentiality of these records really isn't confidentiality for purposes of protecting the parents from criticism. I wonder if it really has, if there's really much left of it so far as the child is concerned.
Mr. Dorson, would you apply your same idea to all the stages of the hearing in the juvenile court? You say it on the delinquency end, but are you speaking technically of the hearing on delinquency, or would you include the hearing on disposition?
I would not include the hearing on disposition. At least this case, of course, does not present that question. It would depend upon which aspect of the hearing on disposition you're referring. For example, I should think that there'd be certain types of evidence, social studies of the child's family, that would be relevant in the dispositional hearing that wouldn't be relevant to the determination of delinquency. And I would permit that evidence to be introduced.
But he certainly would have the right to counsel.
Absolutely.
But you wouldn't call for confrontation or things like that?
Well, I think the way I would put it myself would be that no fact that the judge is taking account of in determining whether to dispose the child one way or another should be left undisclosed to the child and his counsel.
But in terms of the procedure for establishing it,
that I don't think I would go that far.
You wouldn't go for and you wouldn't apply the same rule to the preliminary hearing where In some states, they might have a preliminary hearing to determine whether to file or not.
Well, I don't think I would, although there are problems about that because of the right to counsel problem. For example, in this case...
Well, don't you have to think about these things in deciding this case?
That's right. I think you do, because I think that in this case, for example, even before the hearing, there was a question of when the child was going to admit or deny the charges. And in particular, with respect to his right of counsel, as the record here, I think, very dramatically demonstrates, when this child did not deny the charges against him at the first opportunity, according to the Supreme Court of Arizona, he lost the right at that point to an adjudicative hearing. Now, naturally, we would say that this was a critical stage of the proceeding, and he would be entitled to counsel.
I think it'll come up all the time, whether or not when there's been an event and a complaint against somebody, against some child, and the question is whether to file or not, and would you say that the probation officer or whatever, or the social service worker who's determining whether the formal petition for the court should be filed,
I would not...
should talk to the child at all?
No, I wouldn't say that. But I do recognize, Mr. Justice...
What would you say? That he should talk to the child?
I would say he should.
But his counsel should be there?
Well, that's right. Although I'm not taking that position in this case. I'm taking the position in this case that at the core of the hearing process, which this case demonstrates, counsel is certainly necessary. And the amount of prejudice that this record seems to me to show regarding the rights of this boy seems to me to be conclusive on that point.
Well, Mr. Dorsey, but you're taking this position as a constitutional right.
That's correct.
Now, can you suggest how we would distinguish in terms of the times when an adult is entitled under the case of so far to counsel, the case of a student?
I'm not so sure I could suggest a distinction, although it is clear not only because the question wasn't raised, but because the question in this case could not have been raised.
Mr. Dorsey, we appreciate that, but you can't limit this case to just this case.
Well, I've answered the... Well, I've tried to answer you by saying that I can think of no distinction. If there is a delinquency proceeding...
Can you think of a distinction if we say that he's entitled to counsel as any adult would between that right and the right to a public trial?
Well, I tried to show a possible distinction. Mr. Justice Ford has pointed out that there may be problems in the formulation I made.
I suppose, Mr. Dorson, that there are degrees of what is a public trial, and that one might very well take the position that the trial, so to speak, of a juvenile in the judge's chambers with nobody there but the juvenile and the judge would be a constitutionally offensive, but that perhaps a trial from which newspaper reporters and the general public were excluded might not be constitutionally offensive, and somewhere in there, isn't that possible?
I think it is, and similarly in connection with the question...
How is it possible? How is it possible?
Well, I think...
If it's a question if a man's entitled to a public trial, how is it possible, except conceptually, to draw a distinction between a boy that's 19 and somebody that's 23?
No, I would not draw that distinction, Mr. Justice.
You would?
I would not.
And neither...
And I would like to comment, if I may...
I would suppose you'd draw from the fundamental fairness due process. Context of what is fundamental fairness for an adult, what is fundamental fairness for a child, given the purposes of these statutes.
I would say that I might draw it, though, between a child of 8 or a child of not, between a child of 8 and a man of 21. I might think of a way in which the proceeding...
Well, if you stick to the words of the Constitution and forget the words fundamental fairness, what would you do?
Well, that would present a hard question. I would like to comment, though, on the question Mr. Justice Brennan and Mr. Justice White raised, because I can think of a possibility in terms of having welfare workers or probation officers who are insulated from the delinquency hearing, who are insulated from the adversary system dealing with the boy in a preliminary stage without his lawyer. I would have to see that system. But it is possible for me to conceive of a system where that welfare worker, especially if the boy is not with his parents, dealing with him on a confidential and private basis. But that would be a very specially constructed system, and I would have to see it before I'd want to...
Well, on Mr. Justice Brennan's question about a public trial, I don't suppose that in terms of the public constitutional right to public trial, that the defendant and between the defendant and the prosecutor, the courtroom can be locked up. And if the press wants in, the press gets in. And what would you say about that in a juvenile court case, where both the parents, the child, and the court wants the trial closed? Somebody else says, like newspaper man says, no, we don't want it closed.
Well, that is the hard question that Mr. Justice Harlan and Mr. Justice Black have expressed the opinion on. I could see a distinction being made between an 8-year-old boy and a 17-year-old boy. That is as far as I think I can go at this time, because I'm just not sure how I would...
Well, there is some opinion to the effect that even in the case of adults, you don't have to have a television camera in the courtroom to make it a public trial. Is that right?
That's correct. Well, the Estes case disposed of that.
And that you would say would apply to the child, or to the adult.
I certainly would say it would. Well,
you don't give it your...
Pardon me?
You say it doesn't have the your civil.
That is right.
It has not been held.
It has not been held, and this case doesn't present it, and there was no request for it. The facts of this case, though, are what I would like now, in the few minutes remaining to me, to address the Court's attention to, because this record, as I've tried to state it as well as I can, does show that this boy was prejudiced in countless ways, not only because of the absence of counsel, but because at no time was either he or his parents informed of the specific charge upon which the judge ultimately made a decision. If a lawyer were present, for example, the lawyer would have tried to establish exactly what the charge was.
As a matter of fact, I'm still not clear. Are you, Mr. Dorson?
Well, the judge, I don't think, was entirely clear, because he said at one point that on page 61 of the record that there was probably some other ground for the decision.
Yes, sir. And the determination of delinquency, as I understand it, to take into account not only the specific incident at issue, but also the boy's record.
That's correct.
And all we have here is these vague remarks to which you refer.
I also think it's important to stress...
That is correct. Doesn't it make that quite different from a conventional criminal trial? If a determination of delinquency depends not on specific acts of misconduct, but only upon those in reference to it, the totality of his previous record, doesn't that make this whole
I wouldn't think so.
Entirely different bird from a criminal trial, where it's generally considered prejudicial to bring in anything about his previous conduct, except the specific misconduct with which he's charged.
Well, I think it makes it different, but I don't think it makes it substantially different. And the reason I don't think so is that if certain facts, which are alleged to be true by the state, are going to be taken account in determining whether a boy is going to be adjudged as a delinquent and his freedom taken away, those facts should be stated in advance, specifically and in due time, so that preparation for the case can be made.
Sure.
In this case, the notice was given at 7:30 or 8 o'clock in the evening of June 8th, and the hearing was the next day.
As I understand it, Mr. Dorson, the theory is that there are specific acts, specific incidents upon which a finding of delinquency has to be made, not some general amorphous reaction to the boy. But in this particular case, as I understand it, there was one immediate incident, namely the telephone call. There was this reference to the purse taking by the boy's companion, at which Gault himself was present. And then there's this vague reference to an incident involving a baseball glove.
That's correct.
And that's it, isn't it?
That's correct. The appellees in their brief...
And there's nothing in this record that illuminates what that baseball glove incident was, and nothing beyond the bare words of the report with respect to the purse taking.
That's correct. We in our brief, we'll rest on our brief on the privilege against self-incrimination point and the point relating to...
Mr. Wilson, I just ask one. Have you given out awful lot of materials and filed with it here, from all around. Is there enough in this to tell us how far this progression within the states, either by statute or court decision?
Yes, the brief of the National Legal Aid has as good a compilation, I believe, as has been made in this field.
Briefly, how extensive this movement?
Well, it does. The legal aid brief points out, with respect to some of the items that have been raised this morning, that 78% of the jurisdictions give a right to counsel, 89% provide confrontation of witnesses, and 70% the privilege against self-incrimination, and almost 90%, I believe, a right to an appeal, and comparably high percentages. In other words, it has come to be recognized over the past few years, in view of the scholarly criticism and the work of the courts, that these rights are essential. They're in no way inconsistent with the therapeutic and dispositional aspects of the juvenile proceeding, that the specific facts, as Mr. Justice Fortas stated, are those that have to be rebutted, that a lawyer is as essential or more essential in juvenile cases than it is with adults, even under the rule of Betts v. Brady. Under the fundamental fairness test of Betts v. Brady, it was well established by this court in Demirlier and other cases that the age of the defendant was a pertinent factor to take into account in deciding whether it was fundamentally unfair not to provide him with a lawyer. Our position...
Do you know how many states, if any, provide counsel if they're unable to obtain them themselves? Is that in your brief?
It is in the...
If it's in the brief, don't bother them. Go right on with your argument.
I'd like to answer it if I can. 74%, according to the legal aid, in appendix page 10A of the legal aid brief, 74% is provided if the child cannot afford it.
Of the states?
That's right.
The courts require that, do they?
That's right. And of course, in this case, Mr. Chief Justice, it's very plain that even though the Supreme Court of Arizona said that Mrs. Gault knew of her right to retain counsel, that is far from providing the right to counsel that we believe the Constitution requires. First of all, it's Gerald Gault's right, returning to a point that Mr. Justice Stewart alluded to this morning. Secondly, the right we believe is required by the Constitution is the right to assign counsel if the boy can't afford it. Instead, the Supreme Court of Arizona said that the parent or the probation officer can act as counsel. Now, of course, if the parent himself were before the court as a defendant, he would be entitled to a lawyer because on the theory that he couldn't defend his own case. But when the child is in a position of a defendant, when the child is before the court with up to 6 years of his freedom to be lost, somehow the Arizona Supreme Court finds that the parent can satisfactorily act on behalf of the child as a lawyer would. And as far as the suggestion that Officer Flagg act as the lawyer, the probation officer in this case, it seems to us that this is even less realistic and less fair. There's a flat conflict of interest. Flagg is the person who signed the petition. He signed the petition on behalf of the state in which he said that he is informed and believes and therefore alleges that Gerald Gault is a delinquent. That's on page 80 of the record. Flagg did not do a thing for Gerald Gault. It's well established that he didn't inform Gerald Gault of any of his rights throughout the proceeding. Instead, what he did try to do was to get a change of story, as the record points out on page 49. He was certainly acting as an adversary. In short, our position is, with respect to a lawyer and with respect to the various other constitutional protections that we believe to be fundamental, that the absence of a lawyer does not mean that we'll have a harmonious, informal, non-adversary proceeding. Instead, it means that we'll have a one-sided adversary proceeding.
That's right.
A one-sided adversary proceeding in which the cards are stacked against the child from beginning to end. And we suggest that this court at this time recognize, for example, in the case where a father...
So I like that point that he makes, is that there might have been some idea in someone's mind that maybe getting rid of the lawyers will make things easier or make things more informal or make things better. And what he's like is like, no, not so much. It just leads to the abuse of the accused, which is kind of what you would expect. I mean, or what we might now come to expect in modern sensibilities. So it's like, let's not bring the lawyers into this. It's like cops, it's like the cops tell you, no, let's not bring in lawyers into this. They just complicate everything. They just slow everything down. Yeah, they complicate everything and slow everything down for your benefit, right? That's the key, right? They slow things down and for your benefit. So it's like, well, whatever noble goal there might have been, what's really going to happen is it's just going to be the cards are stacked. And it's a little bit hard to disagree with that, based on this fact pattern. This is just going to be, a nice informal thing that's going to redound to, the juvenile's benefit. He apparently says to some woman, "Are your cherries ripe?" And apparently 6 years is the correct result for that somehow. So I'm not so sure about that theory about, this is for the benefit of the good. It's for the good that they don't have lawyers. Yeah. I like that. I like that argument.
And his son are alleged to have... Well, I did not mean...
I like that, DA Val. That's nice. That's cute. Your child is formally remanded to a state institution. Yeah, it's not really an institution, though. It's just a school that they can't leave. They have to stay at for 6 years. Unless the Bureau of Prisons or its equivalent says they can go early. Yeah. Yeah.
And I'd like to answer that very specifically, Mr. Justice. I am not suggesting, and I hope my words are not taken to suggest, that there's any intention to do the child in. I said at the beginning, and I'd like to reaffirm, that the purposes of these acts were the highest. The purpose...
By the way, for our members, I'd just like to announce the launch of a new emoji, since I don't think any of you have noticed, not that you'd have any reason to. We added an emoji for the button. So you guys can say, push the button in emoji form. So I added a button emoji. So if you'd like to practice using the button emoji so that you know that it's there for the future, feel free to now practice using the button emoji for those of you who are members. So I do try to be responsive to you guys.
Purposes were to help the child. The problem is that the way the system is developed, as the Supreme Court of New Jersey said just the other day, that fundamental protections are essential. I think I'd like to...
Can I ask you one more question? Could you tell me to what extent around the country the judge sees the social studies before determining delinquency?
I don't know the answer to that, Mr.
But is it widespread or not?
I should believe it would be, but I do not know the answer to that.
Which means that...
You mean looking at the welfare reports or the reports of the probation officer?
Family background?
They're available to him in almost every jurisdiction. Before the determination
of trying out the specific fact of whether somebody made the lewd phone call.
That's correct.
But delinquency, the decision of whether it's delinquent or not, may not be limited to that.
That's right.
And you would say that if it isn't limited to that, every fact upon which the determination of delinquency depends must be tried out.
Well,
even though the judge says, well, look, I never hold a boy to be a delinquent just on the basis of one act. It depends on the whole background.
Well, I would still maintain, Mr. Justice White, that when you are determining delinquency with the loss of freedom, that the facts have to be stated. I don't see how we could urge the contrary in this case.
Well, if a judge says, well, I'll take one issue then, did he make the phone call? And I hold him to be, and then I'll consider that all the rest of this information is only relevant to disposition. I'll find him to be a delinquent, and all the rest of this is information which is available to counsel is a question of disposition, whether I put him on probation or whether
That is the recommendation of the Children's Bureau of the Department of Health, Education, and Welfare.
How about notice, just before you sit down? What should the notice, according to you, contain? Just in this case, they notice about the charge about the phone call, or what else, if anything?
I would say that the notice of the charge about the telephone call, the notice of the possibility that he was going to be subjected to a determination under subsection D, which was never brought before him at any time. I also believe the notice should be in writing, and I believe that the notice should be given to the child. It's his interest there at stake.
Only to the child?
To the child and to the parent.
Why to the parents?
because the parent has
If somebody
an
brings
interest.
a charge against me, they don't notify my mother, do they?
That is true, but the child, in this case, when a child is a child, there is, in his minority, there is a familial relationship.
So it makes it quite different from an ordinary case if you have to notify the parents, doesn't it?
In the sense that maybe more rights
Is
are
there a
necessary.
property right of a child and a parent?
I would not call it a property right, but
Then
I
why
would,
should the parents have to be notified?
because it doesn't. I don't believe it's a
We're
property
talking
right.
here about constitutional rights.
Well, I believe that the parents are in a position to help the child. I believe the parents have a child in the family relationship. And I believe, therefore, as in apparently 100% of the jurisdictions that the legal aid office canvassed, 100% provide notice for the
Well,
child.
you're really talking about at least constitutional
That's
rights.
right.
At least.
I'll reserve the rest of my time if I may.
Mr. Parks?
All right, let's hear
Chief
from Mr.
Justice.
Parks about why we don't need justice for juveniles.
May the court please. The attack that is being made today against the Arizona Juvenile Code goes, in our estimation, to the heart of the American juvenile court system. We, the appellees in this case, consider this the crossroad of juvenile jurisprudence. For approximately 2/3 of a century, in the vast majority of cases, juvenile codes very, very similar, if not exactly the same as the Arizona Code, have weathered constitutional attacks. And I think at the outset, with considerable justification, even opposing counsel as a critic to the Arizona Code will admit that it is incumbent upon a jurisdiction to treat their children differently than they would an adult offender, if that would be the proper phraseology. The conflict, of course, arises entirely with, on the one hand, what is required by due process, fair treatment, and the sociologist's concept of what is proper treatment in terms of the fact that we're dealing with a child, the individual of tender years. Well, at the outset, in proffering the cause for the state of Arizona, I think, as our court has explicitly stated, they are interested entirely in the individualized justice approach to children's problems. This is their main aim in regard to handling the problems of youth.
What do you think this is such a big crossroads, right in this case, for New York?
Well, in regard to my estimation of the New York provisions, Your Honor, I believe that New York has gone beyond their crossroad.
So this case is no crossroads for them anyway.
No crossroad
And how
for
about
them,
California?
Mr. Justice.
How about
Why?
California?
California, they have made an inroad on their crossroad, I believe, while they haven't gone as far as the potential constitutional ramifications could conceivably
What
take
about
it.
Illinois?
Catching me short, Mr. Justice.
Well, I mean, you say this is a crossroads for the juvenile court system, but that may be true in your state, but it may be true only in certain states.
In certain states. And of course, I look through the monocle as seen through the state of Arizona as to what our conception is of a proper functioning juvenile system.
And you will say why you think that this view of yours requires that the trial, the evidentiary hearing, must take place as you
Certainly
they
will.
must take place rather than the way the petition.
Mr. Justice White, I certainly will.
Well, I hope, let's see if that can be broken down a little bit. Will it interfere with individualized treatment in the Arizona conception for the child and the parent to be given written notice?
Certainly not. Certainly not.
Will it interfere
Mr.
with
Justice.
the individualized treatment for the...
Ooh, Karen O cites a citation from Supreme Court, I think. Ooh, what's WN? What is WN? Self versus Ray. What is WN? I'm not familiar with that citation. What is that W? Wisconsin legislature? No, that doesn't sound right. What is WN? Oh, it might be second. Yeah, Wisconsin legislature. Self versus Ray. Supreme Court of Washington en banc. Very exciting. Ooh. The common law is the real law, the supreme law of the land. Codes, regulations, policies are not the law. Saul versus Ray from Supreme Court of Washington, en banc, which is interesting, incidentally, because we don't normally talk about en banc in Supreme Courts, because normally most en banc Supreme Courts are definitionally en banc, although some states don't do it that way. All right, so let's see what this case says, because I'm interested. You got my attention. All right, so let's see what this case says. We'll take a deviation. Let's see. All right. Matter before us is on a petition for writ habeas corpus which raises the constitutionality of the law. Petitioner was convicted of the crime of murder, first degree, in the Superior Court of King County, Washington, by special verdict which inflicted death penalty. Sentence was accordingly imposed. Petitioner appealed to this court, where judgment sentence was affirmed. His application to the United States Supreme Court was subsequently denied. After filing the habeas petition in this court, execution of judgment sentence was stayed by order of Chief Justice pending consideration and disposition. Petitioner in this course raises the question of constitutional law. Well, Section 1, Chapter 112, Laws of 1919, which provides that the jury in prosecution on the charge of murder in the first degree shall, by special verdict, determine whether the death penalty shall be inflicted, enacted in violation of the Constitution of Wisconsin, which provides that no act shall ever be revised or amended by mere reference to its title, but act revised or section amended shall be set forth in length. Okay, so if you want to amend something, apparently in Wisconsin, apparently in Washington, if you want to amend something, you can't just do it by like saying as to title X, strike out this language, insert this other language. You have to lay out the entire thing in its entirety, I suppose, for clarity. So most of the time, well, not most of the time, but a lot of the time in statutory things, you'll see like, as to like this to this title, strike out this language, insert this language, and it won't be written. It'll be written by its insertations and deletions. So apparently in Wisconsin, they don't like that with the insertations and deletions. They just want you to relist the entire law every time, which I suppose does make for some clarity. So that's kind of nice, actually. All right. Anyways, is a statute as a statute which is mandatory on its face, and in fact of a prior legislative act violated of the Constitution, when it purports to amend a section of the code, compilation, makes no reference to legislative acts sought to be amended, and requires reference to a prior act to ascertain the legislative intent. So apparently this is an amendatory statute of a prior act, but it doesn't make reference to the act sought to be amended. So it's just like the entire thing. And also, the intention of the legislature was not copied over. So it's just because often you'll see sometimes you'll put it in the code, but very often not. Usually it's more like all these kind of prefatory clauses that aren't really important, but so it's like, do we need those like prefatory clauses that are not operative? Do we need those again? Or is it okay that we just basically incorporate that by reference from the prior thing? So we also need all that prefatory wherein clauses, or do we just need the operative stuff? All right, fair enough. So basically you have to rewrite the entire law, add a comma. That's kind of what it seems to be like they're talking. Yeah, it seems to be like what they're saying, which, maybe a little bit inefficient, but at least it's clear. So that's nice. Anyways, pressing on. The basis of the petitioner's assertion that both the purported amendment of the law relating first-degree murder by laws of whatever and the amendment of whatever were violation of the above quoted constitutional provisions found in legislative history of their antecedents. So, in order to determine that this is improper, I am looking to the legislative history of things that came before it. Okay. Starting with Criminal Code in 1909, which provides in Section 140 that punishment for first-degree murder should either be death or life imprisonment. In discretion of the court, our attention is called to the following statutory enactments. Law of 1911, which authorizes the legislature to refer to some annotated code when amending or repealing existing statutes. So apparently they can refer to some set of laws as the basis from which they're amending. Okay. Laws of 19th, which purport to amend something by abolishing death penalty, prescribing life imprisonment as a sole punishment for first-degree murder. Law of 1915, when adopted that code that we talked about earlier as the official compilation of existing statutes up to and including 1913. So, that's also something that also Georgia did by a way of comparison, where they adopted basically in whole. They just basically entirely adopted. I forget where it came from, but like someone was producing this compilation of laws as an informal thing, and like I think Georgia did the same thing, where they're like, "Hey, that compilation of laws that guy has been putting together, their compilation of laws is really good. What if we just like made it the law? What if we just be like, hey, that's the law now, all that, because it's all nice and put together in one neat package. Someone's already done the work for us, so we just take this nice thing that someone's already put together and be like, hey, thanks for all that work. That thing is now the law." So apparently Washington did something very similar to that, where they're like, oh, this thing which apparently someone put together is now just the law. Great. And then some law of 1919, which says the section of the law shall be amended as follows to say some specific stuff, which we can probably skip the direct nature of it. Petitioner's contention is, since this last quoted amendment is invalid for reasons stated above, the only valid statute now in effect is some other version, which says that murder shall be punished by either death or imprisonment in discretion of the court. So when we did this amendment, we didn't amend it the right way. It's basically the idea. We didn't amend it the right way. We didn't do what we were supposed to do. Fine. In support of the argument, petitioner relies mainly on our recent en banc decision in a different court. The case involves the laws of whatever, referring to original incorporation, municipalities, and annexations thereto. So when municipalities become municipalities, is to say when they're incorporated, they become a corporate thing, right? The corporation of the city. In the original compilation of some revised Code of Washington, the provision contained in Section 15 were divided into two sections relating to the organization of municipal corporations and some other section relating to permissible areas to be included in what were considered fourth-class municipalities. So apparently Washington has different kinds of cities of different kinds of classes for whatever reason it does, and so it has different kinds of cities with different statuses. So fine, whatever. Apparently, there's at least 4 distinct classes of city. So, fine. Thereafter, by amending law, the legislature purports to amend as whatever, in part, without setting forth the amendatory bill in the full text as amended. All right, so when they amended it, they tried to amend it, but they didn't set forth the entire thing. A majority of this court was of the opinion that the attempted amendment was invalid because it didn't do the whole thing. So the Constitution says apparently you have to amend it by doing the whole thing. They didn't amend it by doing the whole thing. So the court said you didn't amend it by doing the whole thing, so try again. Okay. When all 9 judges concurred in affirming the trial court's dismissal of the action to join the proposed annexation, because some cities trying to hijack some other city, all right, it's annexing. So some city would like to take over some other city, so whatever. They did so for different reasons. So they all agree as to this city not being able to hijack this other city, but they disagree as to why. 4 judges expressed the opinion that the original Commode Committee created by 1941 had produced 2 volumes of compilation of law, which the legislature had adopted by reference only as prima facie compilation of this law. All right, so idea number 1 is they adopted the law, but it isn't really law. It's only prima facie evidence of the law, which incidentally you get into for the United States Code as well. If you actually pay attention, and it almost never comes up, but it's one of those things that it's one of those things that you have to be such a hardcore law geek to know, and I'm hardcore enough to know, right? That certain sections of the U.S. Code are only considered evidence of the law, and certain sections are the law. It is such a geeky distinction. Let me see if I know we're on a tangent, but that's what we're doing now. Hold on, we're ADHDing this thing. So let me see if I can find the listing of it. Hold on a second. U.S. Code sections that are what's the name for it? It's called sections that are, what's it called? There's a special name for it. I want to say dispositive, but that's not what it's called. What's it called? Sections that are prima facie. positive law codification. All right. Yeah. Hold on. All right. We're now ADHDing this to talk about this in the view of the U.S. Code, because this is so fucking geeky. I can't even bother to talk. I can't even imagine that we're doing this. All right. So you've got your friend, the U.S. Code, right? You've gone and looked up the U.S. Code. All right. You've gone to a book somewhere. You've gone to the book of the U.S. Code. You've gone to the book of the U.S. Code and you looked up a statute in the U.S. Code. Is it the law? Is it the law? It depends. It depends. This is how geeky it is. You actually took the time to go to the library and you actually pulled off the copy off the shelf and you looked at it and there's a statute. Is it the law? It depends. All right. So they talk about this idea of positive law versus non-positive law. A positive law of the code is in and of itself a federal statute. The non-positive law is an editorial compilation of statutes. All right. For example, Title 10 of the Armed Forces is positive law. By contrast, Title 42 is non-positive law. Okay. So Congress at some point said, hey, as to the armed forces, as to Title 10 that says here are the armed forces of the United States, at some point they said, this is the law. This is the law. So Title 10, when you look up 10 USC blank, that is the law. Title 42, however, is not the law. It is only a compilation of other laws. And those laws are actually the law, not the one that's in the U.S. Code. All right. The distinction is legally significant. Non-positive law titles are prima facie evidence of the law, but positive law titles constitute legal evidence of the law itself. So if you go look up in the U.S. Code, and it says 10 U.S. blank, right? That is the law. That is the law. But if it says 42 U.S. blank, it's only prima facie evidence of the law. So if there's a discrepancy, because this is how this would pop up, right? This is how it would pop up. If Congress, when you go back and look at the original law, the one they actually passed originally, right? If you go back and look at the original law and there's a difference between the one that's in the U.S. Code and the one that Congress passed, which one wins? So if it's Title 10, the U.S. Code wins. So even if there's a difference in the law that Congress passed, it doesn't matter. But in Title 42, it does matter. So it's such a geeky distinction. It is such a geeky distinction that I bet you dollars to donuts that I'm the only law tuber who knows this. I would be impressed if any other law tuber knows this, because this is such a fucking obscure thing. This is so fucking obscure. That some of the U.S. Code is not really the U.S. Code. It's only kind of the U.S. Code. Some U.S. Code is really U.S. Code. Other U.S. Code is not really U.S. Code. Can you tell the difference? So, basically, long story short, there are now 27 positive law titles in the code. So 27 of them have been codified or recodified. So Title 18, for example, the criminal law, that's codified. Title 17, Title 35 on patents, right? Title 32 on the National Guard. But Title 12 on banks and banking. Well, are you a bank? Are you a bank? Do you not like what it says in Title 12? Maybe you should go look it up and see what it really says, right? So it's such a geeky thing. No one would know this. I amuse myself. All right. So going back to this thing, they also have the same idea in Wisconsin. They have the same idea in Washington. This is what they're talking about. All right. So this is what they're talking about. So 4 judges are of the opinion that this code committee produced 2 volumes of compilations of law, which the legislature had adopted by reference only as prima facie evidence of the law, but isn't actually the law. Okay, so when we looked at this thing the legislature passed and be like, this is the law, 4 judges are like, no, it's not. 4 judges are like, no, it's not. It's not really the law. It's only prima facie evidence of the law, right? They only adopted it as a reference to the real law. So if you want to know what the real law is, it's not this 2-volume of compilation of laws. That is not really the law. That's only prima facie evidence of the law. Go look up the original bill that some member of Congress, or in this case, the state legislature, passed, and that's actually the law. All right. So Wisconsin or Washington is doing this exact same thing. Like, is it positive law or is it non-positive law? 4 judges are like, okay, what the legislature did was non-positive law. It's not really the law. It's only prima facie evidence of the law, and no one knows the fucking difference. But that's okay. It's so fucking obscure. It's so fucking obscure. Okay? Anyways. All right. So that's what they're talking about. So 4 judges of the Washington Supreme Court are like, that thing the legislature passed isn't really the law. It's only prima facie evidence of the law. So if there's a distinction, the original thing still governs, not this new thing that they passed. Great. The enacting clause says of the laws said that is derived from Section 15, an act providing for organization, classification, incorporation, government, and municipal corporation. In this respect, the legislature was following its own unconstitutional device for amending a section of the act in disregard to specific constitutional mandate. The act before us does not purport to amend a section of the act, but only a section of compilation entitled a revised Code of Washington, which itself is not the law. Okay, so it says revised Code of Washington, but it's not actually the law. It's only prima facie evidence of the law, and that's what they changed. This is some hardcore geek shit that's happening right now. Okay, such an act purporting to amend only section of the prima facie compilation leaves the law unchanged. So 4 members of the court are like, oh, it doesn't matter that they didn't follow the Constitution because they didn't actually amend the law. See, it only matters. Right? It only matters if the Washington legislature is trying to amend the law, right? If they're trying to amend the law, they have to amend it by, repassing the whole thing. This is called the revised Code of Washington, but it's not actually the law. It's only prima facie evidence of the law. The real law is this other thing, and this is only referring to it by reference. So when the Washington legislature amended the revised Code of Washington, they didn't actually amend the law, so they didn't have to follow the Constitution, which says how to amend the law, because they didn't really amend the law. They simply changed the revised Code of Washington, which isn't really the law, it's only evidence of the law. This is some hardcore geek shit that's happening right now. This is some hardcore geek shit. All right, 2 judges disagreed with the reasoning of that, believing that had been violated and the sections as amended should be enforced. So 2 judges were like, no, we don't agree with all that. The revised Code of Washington is actually the Code of Washington. This is some hardcore geek shit. 3 judges concurred with the first 4 that Section 15 of the original form must be given effect as the law of the state, but found no compelling literal inconsistency between the statute and the enactment. Therefore, they concur in the result. So 4 judges are like, the original should be given its effect, but there's no difference, despite the change. So it was a change of form, but not substance. So this the original still governs, but it doesn't matter. Either one is the same. They're the same. This is some good shit. We've already been describing, I can't believe how deep we're getting in this. We can't believe how deep we're getting into this. This is some real deep shit. All right. We've already described the above several legislative enactments to which petitioners called our attention as bearing the problem before us. It'll be noted that, unlike a statute involved in some other case, none of them contains a decided section. The section of the original act was amended in 1932 as some section of something in which 2015 was adopted as official code up to and including the year of 1913. In 1919, this section, referred to whatever, was again amended. Both in 1913 and 1990, the section as amended was set forth in full length. So it's all fine. The references to the section, the amended act, were to an official code, which itself was Remington Bollinger's annotated code and statutes of Washington, which at some point Washington adopted as the official law. Right? I don't know who Remington Bollinger is, But at some point, the Washington legislature was like, hey, that thing that this guy Remington Bollinger has been putting together, he's been putting together this thing. What if it was just the law now? Because he's done a really good job. He's done our job for us, man. He's put it all together in one neat place. It's all nice. What if we just made that the law? So they did. So the Remington Bollinger annotated code is the actual law, and the revised Code of Washington is not actually the law. Fun. The code sections referred to in the two amendatory bills set out the full thing. Thus, in our opinion, the law is a valid enactment as amended of the prior act and does not violate the Constitution. So after a very long walk on a convoluted road, we're like, yeah, that's fine. Petitioners refer to our decision in which 4 exceptions to operating the foregoing are discussed. We find nothing which bears on the problem before us. In the reply brief, petitioner further argues it's extremely hazardous for the legislature to amend laws by reference to code compilation sections, because that's not really the law. So they're amending the law based off something that isn't really the law. They're amending it based off, okay, so, all right, this is fun. All right, so this is okay. Wow. I can't even believe how convoluted this has gotten at this point. This is such a convoluted thing. All right. So here's the problem. Okay. So at some point they were doing some amendments. They were doing amendments of the not real law, but it was okay because it wasn't really the law. Okay. So they did some amendments of this revised code thing, but it was okay that they didn't follow the procedure because it wasn't really law, so it didn't really matter. At some point after that, they then wanted to amend the law, and they used the unofficial version as the basis for their amendments. Okay? Because apparently the Washington state legislature is so fucking confused, they don't even know what the law is. So, because they got two different sets of books floating around, at least, right? They got the revised Code of Washington, which isn't really the law, and they've got the Bollinger amended code, which is really the law, right? So they made amendments informally to the revised Code of Washington, but that didn't really change the law. At some point later, they then changed the revised Code of Washington, not by doing the insertion and deletion thing, but they made changes by repassing the entire thing. But the changes they made were from the unofficial version, right? Not the official version. So the Washington Supreme Court's like, well, what now? Well, the Washington law says you can't amend the law except by repassing the whole thing, which they did. They did repass the whole thing. So the version they were amending from doesn't matter. That's what this is saying, right? That's what they're saying, right? It's like, yes, they didn't amend from the version that was official, right? If you go look at the changes they made, they amended from the wrong version. They amended from the wrong version, but it doesn't matter that they amended from the wrong version because they repassed the entire thing in full, right? At which point they are in compliance with the Constitution because they repassed the entire thing in full. So the fact they were using the wrong version as the basis of their amendments is irrelevant because they repassed the entire thing in full. So now it is the law, even though what they were amending was not the law, but now it is the law because they repassed the entire thing in full. Yeah. Yeah. And incidentally, this has also been done in the U.S. Code. This has also been done in the U.S. Code because how did it become positive law? How did it become positive law? Congress just at some point declared it was, right? So how did Section 10 of the U.S. Code become official, right? At some point, they just said, this is the version now, right? If this is positive law, they basically repassed all of Title 10, the entire thing. They repassed it all and said, this is the law now. But what if they made a mistake, right? What if they made a mistake? Because what if, like the informal version of the U.S. Code, because it was informal, right? What if the informal version had mistakes in it? What if the informal version had mistakes in it? Well, when it was informal, right, and it had mistakes in it, then a lawyer could be like, okay, no problem. I'm going to go back to the original bill that Congress passed, like the original thing that originally passed it, the original bill, and that is the real version, right? That's the real version, not Title 10. Title 10 is some bullshit. This is the real version. But at some point, Congress said Title 10 is the real version now. So what does it matter if it's a mistake? It doesn't matter anymore, because Congress effectively repealed all of Title 10 and then reenacted it. So what if they made a mistake? It doesn't matter, because Congress just passed a valid law. Remember, they did the whole thing, right? They did the whole thing. They went to the House, they went to the Senate. They said, okay, this is now Title 10. This is Title 10. This is authoritative. This is Title 10. And someone in the background being like, it's a mistake. It doesn't matter. It's the law now, right? Because that's now positive law. So whatever Congress passed in some other version of some other bill, somewhere deep inside the National Archive, where it says something different, doesn't matter anymore, because Congress basically repealed all of it and reenacted all of it. And basically, that's exactly what happened here in Washington. So in Washington State, basically did the same thing. They took the informal version. They amended the informal version, and then they passed the informal version in its totality, all of it. They passed the entire thing, and the Washington Supreme Court said, well, they complied with the Constitution. They set forth the entire version. It passed both houses. It got signed by the governor. So what if it was a mistake? No one cares. That's now the law because they followed the procedure. It's positive law. So this is a really hardcore geeky thing. This is some hardcore geek shit. And I don't blame you, Karen, for not understanding this, because this is some hardcore geek shit. This is some really hardcore geek shit right now. So basically, it didn't matter that they made a mistake because it passed. It passed both houses of Congress. It got signed by the governor. It's the law now. They passed the whole thing from head to toe. They used the informal version as the basis, but now it's the formal version because they passed the whole thing, and bingo bango, we're done. So this is some really really hardcore geek shit. So I don't blame you, Karen O, on this one. I don't blame you for not understanding us, because this is some really, really hardcore geek shit. So yeah. That confuses me. How can one heard all 42 is not the law? See, that's exactly the thing, right? It's not. It's only evidence of the law. It's not the law. It's only evidence of the law. The actual law is the version and the versions of the statute at large, right? Because when Congress passes a bill, it goes into the statutes at large. So the official version is not the version that's in the U.S. Code. The version that's in the U.S. Code is the unofficial version. The official version of Title 42 is in the many, many statutes at large that Congress originally passed. Unlike Title 10, where it's exactly the opposite. All those bills that Congress passed and the statutes at large are now rendered null. And what is in the U.S. Code is the law, not merely evidence of law. It's such a geeky distinction. It is so hardcore geek. So I don't blame you for misreading it, because it is so hardcore geek. So the common law is the real law. Supreme Court land, the code regulations are not the law. It's so hardcore geek. I mean, most lawyers would probably fuck this up. Most lawyers would probably fuck this up because most lawyers won't know what they're talking about. I would imagine that a fair number of my law tubers will not understand what the fuck they're talking about in this case, because it's so hardcore geek. It's something that it's only someone who really loves the law more than life itself who understands this shit. It is so hardcore geek. It's so easy to misunderstand what they're talking about because it's such a niche thing. Like, how would you possibly know, right? How would you possibly know, like when you go pull up the US Code, right? How would you possibly know when you go pull up the U.S. Code, right, from the Office of Law Revision Counsel, how would you know that the little asterisk in front of the word title makes a huge difference? How would you know that? How would you know that the asterisk is actually a very legally important distinction? And slang. Yeah. It's so geek. It's so hardcore. Yeah. So see, like what says this title has been enacted as positive law. And that actually makes a difference. So it only matters if there's a discrepancy between the U.S. Code and the statutes at large. It's like if there's a discrepancy between the U.S. Code and the statute at large wins. Is basically what that says, unless there's an asterisk, in which case the U.S. Code wins. Such hardcore. You have to explain it to most judges, I'm pretty sure. It's some hardcore geek shit. So thank you for that very, very interesting diversion. That was some hardcore geek shit. Yeah, that's some hardcore geek shit. Title 42 CPS unconstitutional, CPS actions, last due process. That's way too expansive. You can't possibly say that all of Title 42 is unconstitutional. That seems absurd. I'm willing to accept the proposition that certain elements of it are unconstitutional, but you can't say all of Title 42 is unconstitutional. That seems absurd. Also, Title 42, CPS. What title are you talking about? U.S. Code, Title 42? Title 42 is for the Title 42 is dealing with national health, right? Public health and welfare, which is not positive law. So that's like the one that establishes the CDC and stuff like that. So yeah, not all of Title 42 is unconstitutional. That's absurd. But yeah, don't get too excited.
A counsel to be provided to them.
Well, this, if you would wish, I will go into it now. I had hoped that I might just give you the basic foundation for our reasoning.
All right, I'd just like to get the list from you here. So you think that maybe it would interfere with individualized treatment if counsel were appointed for the child?
Definitely, Your Honor, definitely.
I suppose the child were given the warnings that he didn't have to say anything, and if he did say anything, it could be used against him. You think that would interfere with individualized treatment? In other words, if he's given an opportunity to avoid self-incrimination, would that interfere with individualized treatment?
That is correct, Your Honor.
You think it would?
That is correct. To be warned of a right against self-incrimination. To give that warning in every case.
That's bad.
That is correct, Your Honor.
How about appellate review? Would that interfere with individualized treatment?
If the legislature so deemed that as the law of our jurisdiction, then so be it. I take the position that the failure of our legislature to define an absolute channel of review did not deny due process.
Now, I'm not asking that. I say, would it interfere with what you say is Arizona's objective, which is individualized treatment? Suppose you provided a right of appeal, right of review. Would that interfere with the individualized
In good conscience,
treatment?
I would say no, Your Honor.
And how about confrontation? The requirement that the accusing witness testify in front of the child or the child's counsel or child's parent or all of them. Would that interfere with individualized treatment?
In cases where the charges are denied by the child, I think it is a requirement for due process.
You think that is a requirement when the child denies?
That is correct.
How do you construe this record? Was this a
Well, I would just
denial
mention
or...
that
Sir?
Supreme Court of Arizona I wouldn't say sidestep the issue. They took it front on by deciding that in this specific instance it was not a relevant argument.
Yeah, but usually in a criminal case, unless there's a clear admission, case proceeds as if there'd been a not guilty plea. Isn't that right?
That is correct, Your Honor. However, as I will intend to interpret the facts of the case, I think they are a bit distorted by appellants as the actual admissions that were made.
I'm asking you for your view. Because, well, do you agree that confrontation in a case of a juvenile is a constitutional necessity where there is a denial?
I think I wouldn't go so far as to say it's a constitutional requirement, but I would be the first one to accept the concept that fair treatment would warrant a rule that would decide if the child has denied the charges, that there be a fact-finding procedure to determine whether, in fact, the facts which have been alleged are correct or incorrect.
Well, unless you're going to confess error here, then you have to take the position that the Gerald Gault did not deny.
That's correct.
The act of which a complaint was made here, but on the other hand, he didn't admit it, did he?
As I will show the court in the record, there were specific references made to the statements made by the boy, not only to the judge, who on 2 different occasions at the habeas corpus proceeding specifically stated,
I should re-record a video about that, but I'm not even sure how I would explain it in a video. It's such, I'm not sure how I'd explain that. It's so niche.
I talked to the boy and asked him if in fact this telephone call was made. The boy gave the exact set of facts as is related in the record, that he had dialed the number and he had stated some of the words, although not the most serious of those words. This was also substantiated by Deputy Probation Officer Flagg, who also testified at the habeas corpus proceeding, that the boy on 2 different occasions admitted to him that he had stated the words involved. Mr. Dorson had relied on an extract out of the record where at the second hearing on the 15th, they again went back into talking to the boy to try to find out the specific facts that the judge wanted to delve into at that time.
Well, to get back to the other point, if you think that confrontation where the boy denies guilt would not negate individualized treatment, why is it that you are so worried about self-incrimination, about telling the boy that he's got a privilege against self-incrimination?
Well, I think the one potential disadvantage to confrontation is to bring the child into the center of an adversary proceeding with all the taint, perhaps, of a criminal proceeding that we try to remove from the child.
I thought you said that was all right where the child denies guilt, that you thought that was an essential element of fairness.
Well, of course, I'm going outside the record now, Your Honor, as far as my...
maybe you may not be, depending on how one...
Because it's my position that I think fundamental fairness requires a fair, fact-finding determination of an adjudication of delinquency. And if the child denies it, I think that it would be incumbent upon the discretionary powers of the judge to ensure that the subject is aired to that degree which, to his satisfaction, and by clear and convincing evidence, will indicate that there has been a violation, if there is a violation, or that the facts alleged indeed did take place.
You know any way to establish anything by clear and convincing evidence, short of providing fundamental due process?
I think the two would run hand in hand, Your Honor. Of course, if I just may answer the one remaining question left unanswered, what is the difference between that and the privilege against self-incrimination to warn the child of that? Well, this gets right to the basic core of the juvenile system, that everything that is conceivably done is for the purpose of enhancing the welfare of the child. It's the state's last opportunity to take the child of tender years and, in a very, very supreme effort, try to take that child, who perhaps is incorrigible, and make him a good citizen. Now, to tell him at the outset, we're here for your benefit, anything you say may be used against you, you don't have to say anything. I think to even the experts in the field will indicate that this is a very, very bad first step.
What's your rate of recidivism as applied to juveniles in the state of Arizona?
Well, the report that comes out on a county basis in our state indicates that it was below the national level. I don't have the specific figures before us. The report comes out of our Fort Grant Industrial School, which is entirely for delinquent children. They indicate that their number of repeaters is extremely low. Extremely low. And that's
extremely low means what? Something around 40%?
That ones who are in there once
50%?
Normally don't come back.
So that means 40%, 50%?
No, I think they're in 54, 64, I believe, it was in the 20% bracket. Now, I would just like to have the court respectfully bear in mind that when the state acts as the parent's patriae in place of the parent, it does in fact do that. Now, I would respectfully ask the court to just bear in mind that we're dealing here with the child. Now, this is a completely different, if I may start with my argument from this basis, a completely different individual than an adult. All through a child's adolescent years, he goes through a period of limited freedom. He doesn't know absolute liberty and freedom as such is known to an adult. I mean, he has no absolute right to go out and drive a car. He has a limited right to contract. He doesn't have personal liberty to avoid compulsory education. His entire adolescent years, in many cases a direct indication of just how he is going to be brought up, is directly dependent on what proper parental restraints are placed upon him. If a child needs necessary restraints, the parent gives it to him. And I think this was the basic feature behind the first juvenile court. The state steps in and tries its very best, when the parent is not doing the job, to do that job in the parent's place. Now, the facts of this case will bear or lend a great degree of credence to the statements that I'm making here today. This was not a waiver proceeding, in our estimation. Based on the record, we don't think it was a case of where the child denied. He told the judge all, and I think his statements indicated that he had stated some of the lewd remarks that were made on the phone. The facts, as stated by Mr. Dorson, were basically correct. However, he made one statement that I have previously just touched upon, that at there were two hearings. The boy was picked up correctly on the 8th. He was placed in a detention home in this very, very small community in Arizona, Globe, Arizona. And the probation officer, who was directly involved in this case, Probation Officer Flagg, stated that he did not come back to the probation center as part of his activities until later on in the afternoon of the 8th. He immediately went down to the detention home, and this was, I believe, in the early hours of the evening. Concurrently therewith, Mrs. Gault came home, found out her son had been picked up by the police, and he was down at the detention center. They met at that time. Now, this was the day before the hearing. Flagg, who is one of two probation officers on the staff of the juvenile court in that county, spoke to Mrs. Gault, and his statement, as I have related in my brief, is to the effect that he talked to Mrs. Gault, he explained everything to her. Mrs. Gault also admitted that this conversation took place. She admitted that when she talked to Probation Officer Flagg, he said, "I am going to try to set the hearing up for 3 p.m. tomorrow." Now, on June 9th, this first hearing took place, as related by Mr. Dorson.
Why did the state, in its capacity as parents patriae, of this 15-year-old boy, pick him up and put him in the receiving home. Was there any indication that he was about to flee the jurisdiction or would not be available for trial? Was a warrant obtained? Does the record show what information?
No, Your Honor, there was no warrant obtained, but I think the record, while it does not specifically pass on this issue, will show that on that specific date, the father was away on his job, some 150 miles away up in the Grand Canyon area. His mother was working. The boy was home alone.
And so this supposedly benevolent parens patriae estate picks the boy up and puts him in what in most jurisdictions one would have to say is whimsically called a receiving home. I don't know your institution.
We like to think of our detention centers as getting the center of our attention, Mr. Justice.
Wow.
Well, I congratulate you if you're relatively unique.
But this...
Ooh, I think he just got disrespected. I'm not sure he noticed. Oof. Abe Fortas disrespects him, and I'm not even sure that 100% that Frank noticed. Abe says, I suppose this supposedly benevolent parent parenti, the state picks the boy up and puts him in, well, in most jurisdictions, one would have to say is whimsically called a receiving home. I don't know if you're institute of, and then he says, we'd like to think that our detention centers is getting the center of our attention, Mr. Justice Fortas. I congratulate you up here being relatively unique. Oh, the shade. Oh, that's some serious A. Fortas shade. Oh, it's like you are using euphemisms. And he's like, and then he tries to come up with this clever reply, right? He's called whimsically call them receiving homes, but they're prisons, but we'll call them something else. We'd like to think that our detention centers are getting the center of our attention. So he comes up with this witty rejoinder, and Ford just slams him down. I congratulate you being relatively unique. I'm not even sure he notices he's been dissed. Oh my God. It's 60 years later and the burn still hurts. Oh, wow.
The juvenile officer, who by law is required to be contacted immediately, in his best discretion, decided that proper procedure in this case was to have the boy taken to the detention center.
It's routine, isn't it? When the
in not all
charge of delinquency
cases.
is
Not all cases.
made, it's not.
Not in all cases.
This boy being home alone, his father 120 miles away, and his mother at work, was any written notice left for the parents when the boy was taken, or any word given to anybody in the household that where the boy had gone?
Mr. Chief Justice, this did not take place. This did not take place. There was no written notice left at the home. We, as appellees in this case, would try to justify it to the respect that Flagg, who was out during the day, as soon as he came to the detention center, happened to meet Mrs. Gault, and we would presume that if he had been there earlier, there would have been an actual notice. He testified, he talked to her, specifically informed her of what the complaint contained, and he also specifically told her where, when the hearing was to take place. No subsequent.
But she had to get that information from neighbors or someone else around the place. The officers left no notice to the parents at all, did they?
No, they did not. They did not. The very, very important factor, I think, that goes to the entire panoramic view of this case is that the boy was not.
Yeah, that's right. I think you're right, Senshi. I'm behind the Wisconsin decision. Our mind of the qualified immunity statute was a misprint in relation to what Congress printed. Yeah, I think you're right. Yeah, the qualified immunity thing was a mistake. The way it was passed. Yeah, where some language got dropped or removed or something. Yeah, by accident. I think you're right. That's a nice little nugget of thing where it was a mistake. So the entire qualified immunity doctrine, as we know it and love it, was built on an error. Yeah, I think you're right. Good note. Good note. Nice memory.
not new, nor were his parents completely new to this type of state action. The boy had his first scrape with the law back in 1962 when, as counsel has stated, there was a theft of a baseball glove. Now, this was disposed of through the probation office intake procedure. There was no formal complaint made, but with the small type of an office that I know that they have in Hill County, this was a thing that was common knowledge to them.
Well, was that ever proved? Did the boy, is there anything in the record, was there anything before the judge so that shows that was proved, that the boy stole a baseball glove? Is there anything to show what the circumstances were? Did he pick it up on the baseball field? Did he break into a store?
Other than there was no written record,
Well, what
Your Honor.
is there?
Well, it's just that where, in this case, as a factual matter, the judge was there back in 1962, his probation officers were there in 62, and they handled it.
But even the judge doesn't say exactly what happened, does he?
Well, while he was not asked to delve into that specific issue, his statements on the facts show he was well aware of what the facts of the case were.
Yeah, well, I have no way of knowing if that's so or that it's not so. The fact of the matter is, based on what you say and what happened here, is that was an important part, that unwritten, unknown, perhaps, so far as we know, unadmitted and unproven incident, was part of the reason for putting a boy in detention for a maximum of 6 years for an offense which, if committed by, or as the immediate consequence of an offense which, if committed by an adult, would have resulted in a maximum of 2 months imprisonment. Is that right?
That's correct. While the judge indicated, Judge McGee, that this was not the entire criterion involved, the boy was still on probation from the February 2nd, 1964 adjudication of delinquency when he was involved with that grand theft. And being on probation, I think the court went through their adjudicatory proceeding, determined whether or not the facts as alleged on this occasion took place, and they took into effect the fact that the boy was already on probation. He was not responding to the therapeutic approach that the court was trying to afford him.
But forgive me, and I'll leave you alone after this, but so far as this record shows on that grand theft incident, the only thing that we have here is a scrap of paper reproduced in this record that shows that he was in the theater along with another boy, and that the other boy took the pocketbook. Is my recollection correct?
That is correct, Your Honor.
And that's all we know, that appears on this sheet of paper. We don't know whether the boy himself was culpable, what the degree of culpability was, whether he participated in taking it, or whether he was just along with the boy. And now the representation is, I don't mean that it's yours, but basic to this whole field, it is said that the state is acting as parens patriae. It's acting as sort of a foster father of this boy. And one of the things that it takes into account is a written statement that the boy was along with another boy in a movie theater, and the other boy took a pocketbook.
That is the basic substance of the prior probation. And I know the court is limited to, in this case, the order signed by the court under that occasion, that they determined the boy to be delinquent and just what the provisions of his probationary period were.
Were they following the ordinary courses followed by juvenile courts in the country as it has developed?
The basic framework, Your Honor, I'd say was complied with. We think it was. As far as notice is concerned, as far as going through an adjudicatory proceeding.
Really? You
we
think
it should be held.
You think this is totally fine?
The parents were given notice of the hearing. Our court said that if the boy had, in their estimation, denied the charges, they would have definitely had a reasonable period of time in which to prepare a defense.
You're simply following the procedure that as it has developed.
That is correct.
And Second thoughts, however, have caused us to question.
I understand.
I don't see that you have done anything extraordinarily bad in what you've done.
No, that
you've
is
been rather following the course that's been followed in the past.
that is correct, Mr. Justice Black. The Arizona court based its decision on the fact that they were going along with the vast majority of cases that have held similarly on similar points. They did not go into the extreme citation stage that they could have. I mean, the case law up until now is relatively replete with cases that have passed on the same identical subjects, where the courts have accepted the parens patriae doctrine. They have said that we recognize a child is entitled to due process. Our question is, what does due process require in this special tribunal? And they have balanced, on the one hand, as I have mentioned, the needs of the individual, and on the other hand, just what the goals of equality are in recognizing the type of individual being dealt with. They have confronted the question.
It places you, whether you believe that you'll get your case, places you in the situation of having to say that, does it not, that they're not entitled to legal notice.
Well, of course, I speak through the mouth now of our Supreme Court, who interpreted our statute by saying the constitutional, not the constitutional, but the requirements of fair play and due process require notice.
Yeah.
And I cannot be absolutely sure, but I know in cases gone by, cases decided that there was no right to notice. The state acted as parens patriae. It could do that as it would without notice. We here are saying that that is required. And these are one of the injections into our juvenile code that I think will take away from the immediate splash made by Mr. Dorson that our juvenile code is bereft of any protection whatsoever. We're trying to equalize what is needed and what is required.
Trying to do it by not recognizing certain federal rights that this fellow would have, except that he's a minor, isn't that it?
Well, if one was to accept the principle that a child has the same absolute rights as a parent, then one would only have one hurdle remaining.
Well, he would have to stay in prison or do whatever has to be done. Because in a sentence, his parents couldn't do it for him.
In regard to taking a juvenile and sending him to a state?
Sending him into confinement. Whatever you call the place is confined.
Of course,
he's the one that'd have to separate.
We tend to think it's not confinement merely because his liberty is limited to the parental restraint level.
I think it's not confinement? Maybe you went a little too far.
We look at it from this point. It is very difficult, and I think it would be naive to argue that when the child goes to an industrial school, he has a right to walk out of the gate any time he wants to. This is not true. The child is sent there for training. It's just like saying if you're going to be sent to school, you're going to school from 8 until 4 or whatever the hours are, and you may leave at 4 o'clock and come home.
Should he?
Well, he is there. He is there on a 24-hour basis, depending on what the provisions are for perhaps his temporary release.
Matter of fact, if you would call the place jail instead of what you call it, that'd be called sentencing to jail, wouldn't it?
If one would consider it a penal institution.
But he didn't have a place to get at home. No parents.
The record shows the father was constantly away. There were statements made by Judge McGee to the effect that after having made an investigation, they didn't think that the parents were performing the function they should. And this was one of the reasons why perhaps one of the items involved is just what function the parents are playing. And if you've got a good child who's not being helped by his parents as he should, the state has an interest in the child, Your Honor, to attempt to keep him on the straight road of life until he gets to the age of 21 when he's on his own.
Well, I thought the concept was that if the parents are not giving the child security, then You're not sent to home in the sentence.
This is a prerogative of the juvenile court as far as sending him home if they wish. The court here...
The juvenile training school. He's sent to training school.
Yes, sir. He has the option of taking the child away from the parents and putting him in a training school, or if it is merely an act of delinquency, which has no correlation to the family life, the juvenile judge has the ability to say the boy is going home, to stay at home, and he'll have a curfew, he'll go to group sessions, he will have these requirements placed upon him. It depends on each individual situation.
Well, he's not that serious.
That's correct.
Yes, so he thought, I suppose, like he is meager, but I suppose he thought that the best thing to do would be to tie up his training school.
And this leads me to a point that has not been brought out, and I think will detract a bit from the harshness of the disposition that was made by the juvenile judge. Gerald Gault is no longer in Fort Grant State Industrial School. And I bring up this fact for two reasons. It perhaps would have rendered this case moot, but under our Arizona law, when a child is sent to the industrial school, he is under the exclusive control of the State Board of Directors of Institutions for Juveniles. He is under their exclusive control and jurisdiction until he reaches his majority or he is absolutely released. Now, in this case, one of the ramifications of the individualized treatment shows that on December 9th of 1964, in other words, about 5 months after he was committed, the boy was replaced in his home under what is commonly called our home placement program. And it's a conditional release where, under many, many circumstances, the boy is allowed to go home for a weekend. And then he is taken back to the institution for training, for development, for guidance during the week, and allowed to go home. He is presently, at our latest report, still with his parents. And as a result of the adjudication here, he spent only 5 months in our industrial school. They applied what they thought was needed on the boy, and now he hasn't been in trouble since December 9th of 1964. Now, the question was raised as to whether or not this renders this moot. In other words, it was raised before I came here. We thought not, for the basic reason that the boy did not have his absolute release. He was subject to the jurisdiction of our board of directors. At any time, he could be taken back without a hearing, etc. I think you might.
I was wondering about the request that the parents made for the recipient of this telephone call, the woman who received the telephone call, to be brought to the hearing for examination as to whether it was this boy's voice or the voice of the other one. And the judge said, as I read someplace, she doesn't have to come here. What about that so far as the fair hearing is concerned?
Well, it is our position, Mr. Chief Justice, that whether or not a complaining party should be there is directly dependent and commingled with the question of whether or not, when in a fatherly manner the juvenile judge says, "Gerald, what went on? What did you do?" And the boy says, "Well, Judge, I called the number and I said some of the words on the phone."
Suppose the judge...
Wow. It's interesting. Well, whether or not we need a complaining party doesn't matter, because the judge asked a fatherly manner what went on. He said, "I called the number and said some words on the phone. How about 6 years?" Wow. 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 That's a lot. Lord.
Doesn't say it in a fatherly manner.
And I'd say he wasn't an Arizona juvenile judge, Mr. Justice Forrest.
Well, I understood, Mr. Parks, that at that time, when they asked for the woman to be present, that there was a difference of opinion as between the boy and the authorities as to whether he had spoken any of those lewd words, and that they wanted her there for the purpose of establishing that it was the other boy's voice and not his voice on the telephone. Now, that it would seem to me, would be enough of a denial so that if there was the right of confrontation of witnesses, that he would have the right to have that woman present so she could be examined as to whose voice it was. Now, I may have stated the facts inaccurately, but...
Well, our Supreme Court, reviewing the entire record, thought that the statements that were made, and there was one person who held the view that Gerald did not make the admission. That was Mrs. Gault. She was the one who was at the June 9th adjudicatory hearing. Father wasn't there. At that hearing, there were statements made as to, could you hear what was stated? Did you know what was going on? And through her testimony on occasion, she says, I think they said this, I think they said that. Now,
didn't the probation officer also indicate that the boy had not admitted that...
That is correct, Your Honor, in regard to the second hearing on June 15th.
Now, this was at the time when they asked for the woman to be present?
No, sir. That on June 9th was the first hearing, and that statement, which is made by Probation Officer Flagg and Judge McGee, is that at the June 9th hearing, Gerald admitted making some of the statements. Flagg testified that at the June 15th hearing, the boy recanted and said that he didn't. And then there is a conflict between the judge and the probation officer, because the judge said that the boy told him again on the 15th that he had made some of these statements. And I can just state that our Supreme Court...
Let's state for the record that the chicken soup kicked ass. Extremely good. Recommended. I have another thing of chicken, so when this chicken soup runs out, I'm making more chicken soup. Chicken soup kicks ass. That is all.
Selected the facts and decided that the boy had in fact made the admissions that were contended on our behalf during the appeal, and that there was no need to go into the confrontation issue because there were in fact admissions. And now
in Arizona, is it appropriate or permissible to make a finding of delinquency on the basis just of the admissions of the juvenile? You accept the admissions without corroboration?
Mr. Justice Fortas, this was the case of first instance in that regard in Arizona on this issue, and they are directly saying that. When the boy admits that there is no relevant issue on that subject, and they have disposed of it.
I mean, that's what this case stands for.
Yes, sir.
There is a rule in other jurisdictions, isn't there, to the effect that admissions juveniles have to be corroborated before they will be accepted as a basis for it.
I know that deals with cases of where I believe there's a question of who is an accomplice and who is if there is a violation involved, if they are an accomplice. I don't know of any specific cases where any statement by a juvenile has to be corroborated before it's acceptable for its probative value. I would like to just move on to, I think, probably one of the most important areas, and that is the right to counsel. I have relinquished a certain portion of my time to Mr. Merritt Green, representing the Ohio Association of Juvenile Court Judges, who would like to make some statements on the case at hand. The positions being taken by appellants in regard to the right to counsel are based entirely upon what they consider and believe to be the requirements of due process. In doing so, they are definitely and entirely equating the juvenile proceeding to a criminal trial. We contend that this is not so. Our statutes specifically hold it is not to be considered a juvenile or a criminal trial. A child is not convicted if he is found delinquent. His statements can in no way be considered the conviction of a crime. Our state has gone perhaps one step farther by trying to protect the child as much as possible by requiring that 2 years after an adjudication of delinquency, the records will be destroyed. Our legislature saw this as a means of avoiding the problems of when the boy gets to be 20 and 21, where he has the record available for perhaps civil service or the FBI to see. That is destroyed. We have specific provisions for the destruction of those records. We'd like to think that this is a means of taking this proceeding, and if it has performed its function, of taking it and dispensing with it, and therefore dispensing with any potential problems that could arise out of that hearing beyond what was contemplated by our statute.
Well, what records are destroyed, though? Now, here's a case where a boy might have been kept in custody for 6 years, and you certainly don't destroy all records after 2 years. What is destroyed and what remains? There must be some record that Gerald Gault was subject to this court order that would survive for the 6-year period.
Your Honor, Title 8, Section 238 in our juvenile code provides for destruction of records after 2 years after the discharge of a child from the institution to which he may have been committed.
That would mean that this would be...
By the way, good news. Since, we didn't have a stream this morning because of my acting class, which also went well, but I'm happy to announce the return of Hat. Hat is better. Hat is better and would like to know that it missed you and it loves you. So for those of you who are concerned about Hat, I'm happy to report that Hat is back and in great shape. So all respect to Hat. So where did Hat go? Hat was damaged. Hat was damaged. We didn't have it yesterday on stream because Hat was damaged. It was distorted. It was distorted by the Texas sun and heat. So we had to take it to a hat shop and take it to get hat repair. Fortunately, a little bit of steam was able to put it back into place. So Hat is better now.
Destroyed after he gets to be 21, Gerald Gault.
If he did not,
unless he gets an absolute discharge prior to
that is correct.
That time.
That is correct.
And does you construe that as meaning all records, including the records that he's been in the institution? Is that the way?
They make specific mention, Your Honor, to the fact that destroy the records of the proceedings.
Just of the proceedings.
Of the proceedings.
But the fact that he had been there presumably would still remain on the record.
Of course, I couldn't make a specific statement that in all cases the proceedings are destroyed and the background information is retained. I should imagine that in some cases there is a variance one way or the other. But I think by the requirements of statute, it's only required that they destroy a record of the proceedings.
Which is cold comfort in terms of we've been talking. And that is to say there may still be, presumably still would be a record that the boy was sent to the institution for such and such a period, for such and such, on such and such a basis.
There is a possibility of that, yes, sir. As to the right to counsel, I necessarily find myself arguing a philosophical point of view, which is the basic foundation of our juvenile system. We don't think the word liberty is used in the same sense that that word is used in our constitutional provisions. We think that, of course, there's a clear cleavage between our position and appellants that we think that a probation officer can serve a function for the child. We try to remove as much of a traumatic experience for the child as possible. The probation officer acts for the child. There is a requirement that the probation officer be present during the hearings and represent the interests of the child. Of course, appellants take the position that this is not possible. I argue not in the same vein as one would have perhaps argued the Miranda decision, that we don't need this type of procedure because it's not required. There is an added factor here. There is a reason why an absolute right to counsel at this proceeding shouldn't be a rule absolute. Our court definitely left the discretion of the appointment of counsel up to the juvenile judge. And I can say with a great degree of frankness, there are many, many proceedings in the state of Arizona where the discretion of the juvenile judge is used to say, in this case, we think counsel is required, and therefore it shall be. This is a case where the judge did not use that specific discretion. We think a rule absolute would require or would destroy the flexibility of the juvenile court.
What?
Does your juvenile court judge, have the right to...
It should be up to the mercies of the judge as to whether or not you get a right to an attorney. If they had to give you an attorney in every case, it would destroy the judge's flexibility. Yes. Yes, it would. Yeah. Yeah, it would definitely destroy the flexibility. Okay, great.
To say no lawyer can represent a child in this particular case?
No, Mr. Chief Justice. Our Supreme Court decided back in, I believe, the early 1950s that if the parents wish to retain counsel, they have that right to retain counsel of their own choosing, and counsel cannot be prohibited from performing whatever function they see fit at that hearing.
I wonder how you would distinguish, though, the situation where if a child of a wealthy family wants to bring a lawyer there to represent the child, that they can do so, and he can have representation all the way through the proceeding on the theory that it will be helpful to him. But on the other hand, a poor family that can't afford an attorney must remain bereft of one and must rely on the probation officer. Now,
there is a distinction, Mr. Chief Justice, between what the court perhaps would think is the best procedure for the child. They might think it would be better if we just came in here, we're going to encourage the boy to talk as the first means of rehabilitation. It would work better without counsel to perhaps stymie that process. But we can't go so far as to say, because we think that specific procedure is correct, we're going to say you cannot have the right to counsel appointed on your behalf. In other words, if the parents so wish it, we didn't think, our Supreme Court did not think, that we had the power to say, no, you are going to be prevented from doing that. This was the concept of fair play.
And you think it represents fair play for the judge himself to determine whether the child shall have counsel?
Shall have counsel, and the circumstances need it, and that the circumstances of the case might perhaps warrant it. That's correct, Your Honor.
Apparently, this judge didn't see the need for this particular juvenile to have counsel, even though he was facing 6 years, not as a result of a criminal conviction, mind you, and he wasn't going to jail. What was the phrasing that we decided on? It's a civil hearing with respect to whether or not he'll spend some time at the, what they call it, the school or whatever. Yeah, apparently the judge didn't see the need for an attorney. Why would this? I'll just speak to him in a nice fatherly way, and I'll send him to a magnet school. Okay.
As far
Yeah, industrial school. Yeah, that was the particular phrasing I was looking for. Couldn't quite come up with it. Thank you, A. Hedinger, for pulling that out of the memory. Yes, an industrial school. It's a school for industry. Uh-huh. What was the name of the industrial school exactly? Does anyone happen to have it? I wonder if it's still around. Let's see. What was the name of the Washington? What was the name exactly of it? Washington Industrial School. What was it called exactly? Hold on. See if we can find out exactly what this is called. In Ray Gault. Let's take a look. It had an exact name. It had a name beyond just State Industrial School, didn't it? I think they mentioned it earlier in the opinion, or some earlier they mentioned the exact name. Didn't have like a name. Arizona State Industrial School. I know. Or was why did I think it was Washington? Oh, the industrial school. Okay, is this what it is? The State Industrial School, Fort Grant. Yeah. Okay. So apparently the State Industrial School was created at Fort Grant, a U.S. military institution, which was then transferred to Arizona to use as State Industrial School for wayward boys and girls. Neat. I was trying to figure out why they closed it down. It became part of the Department of Corrections in 1968. I think it's still around. That's cool.
As far as the general subject on counsel, philosophically, it is our position that the spirit of the law, rather than the absolute letter, constitutional constructions, which I agree individuals can go and pick out certain statements made in constitutional questions and justify their position. We are of the opinion that in balancing the needs of the individual and the goal of equality, that the spirit of the law, rather than the absolute letter of the law, would require this court to accept the juvenile proceeding in the way it has been functioning and the way it will function in the future. I just will make my final statement on the right against self-incrimination, just to give the court some of the reasons that individuals who have commented on the subject have stated there is a reason why the child should not be informed of that right. Our court specifically did not say the child doesn't have the right, only that the court did not have to advise him of that right. First of all, we contend that there's no criminal conviction involved, number one. Number two, a refusal for the child to testify or to talk to the judge cannot be punished. It, in many cases, just indicates the fact that the child is antagonistic to society, unwilling to cooperate, showing a further need for perhaps additional guidance. There's no prosecutor present. There is no individual to twist what the child says. We would prefer to think of our juvenile judges as talking with the child in the most reasonable respect, encouraging him to tell the truth.
When it gets you 6 years, I don't know.
As far as a right to
I bet you
appeal
would
and the right
encourage
to
them
a
to
transcript, I would just rest on the statements made in my brief, and to the effect that we think the decisions on the subject at the present time indicate that This is not a denial of due process.
We have no problem with this on due process grounds. Anyone else have problems with this in chat on due process grounds? It's like, we have this kid brought forth where you have the complaining witness is nowhere to be found. The judge talks to him in a fatherly voice. No right to an attorney, no right to remain silent, no right to confront the accusers against you. 6 years. This is not a due process problem, says Arizona. We think that this is super great. We like this. And we don't see the problem, Supreme Court. We're not sure what you're on about. Due process? What are you talking about? Damn.
I'll now relinquish the remainder of my time to Mr. Green. Yes, sir.
Fifth Amendment, no. More the point, 14th Amendment is more of the problem.
I know.
The more of the problem is the 14th Amendment.
Many of the states are varying now. I know there are 5 that require appointment of counsel after request and a finding of. In Arizona, it is left entirely to the discretion of the juvenile judge. That would be contrary to the decision of our Arizona Supreme Court. Not appointed counsel, Your Honor, in regard to if, then the decision is left to the juvenile judge if he thinks it is required. And I would say that in our most populous county of our state, this is a procedure that is given entirely if the parents ask for counsel. The court bends over backwards to give it if, under the circumstances of the case, they think that the ends of justice would require that. It's up to the judge, Your Honor.
Mr. Green?
Mr. Chief Justice, may it please the members of the court. Mr. Parks was kind enough to relinquish some of his time to me that I might talk with you as Amicus on behalf of the Juvenile Judges Association of the state of Ohio. It will serve no purpose for me to walk over the ground that's been plowed and worked on by counsel before me. I think my role here is that of, I did conceive my role here as that of voicing my concern on behalf of those people, thousands of people who preside over and work within the framework of the juvenile court system. That a decision does not come from this case which would, in effect, wipe out our present juvenile court structures, procedural structures. I think that concern arose out of the thrust that was in the brief and in the argument, I believe, of the appellant, which in effect asked this court to impose upon the juvenile court procedures the doctrines that the court has laid down in Gideon, Escobedo, Miranda, and so forth, to apply those to delinquency cases. It's easy to become confused in not distinguishing, if you can distinguish, between felonies, misdemeanors, and delinquencies. The state legislatures in all 50 states, I believe, have in their wisdom in defining how they're going to treat transgressions of the rules of good conduct and order that our society requires, have set up classes of these transgressions as felonies, misdemeanors, and delinquencies. Now, we have always, within this framework of the juvenile court system, have always, if I may say it this way, not considered what would ordinarily be a crime if committed by adult, a crime if done by a youngster. Well, Mr. Green, the distinction between misdemeanors and felonies is based on some difference in the elements of the act.
That's right, sir.
But the distinction between delinquency and, on the one hand, felonies and misdemeanors on the other hand, may or may not be based on a difference in the elements of the act.
That's right, sir.
It may be based merely on the fact that who does it, whether he's 18 years old or 19 years old.
That's right. That's right. You see, this may be an oversimplification of the statement, but the delinquency is not a crime. Children do not commit crimes. They become delinquent. And they are not treated as crimes until the court that has the exclusive jurisdiction releases them to the adult court to be tried as an adult would be tried, as in the Kent case. The court will remember that in the Kent versus United States case, the court, I believe, recognized that the juvenile court system was of such, well, I think the court says that in that case that the child was entitled to the exclusive jurisdiction of the juvenile court and its attending protections, and that when the court considered that they should, whether or not this boy should have been tried as a criminal, that's where it became of such vital importance that all of these constitutional protections, such as hearing and notice and of those things, should be carried out. Now, as I say, from the standpoint of Amicus, we are looking at this, I'm frank to say, from the practical aspect of it. While on this particular record...
What is the difference, Mr. Green? Here's a boy, let's suppose that he telephoned this lady and said some lewd things over the telephone. He was picked up. And then he has this, whatever you want to call it, a hearing or whatnot. And the end of it is that he's sent away for a maximum of 6 years. Now, if an adult had done exactly the same thing, he would have been arrested. He would have been tried. He would have been given due process. He would have had a right against self-incrimination. He would have had the possibility of appeal. There would have been a transcript. There would have been notice and writing. Burden would have been on the state to establish his guilt beyond reasonable doubt. There would have been confrontation of witnesses, all because he's an adult. And the most he could have been put away for is 2 months.
Yep.
Now, here's a boy that gets picked up, and he gets none of these safeguards, no confrontation, although certainly this is at the very least a murky record as to whether he admitted that he did it. And he gets sent up for maximum possibility of being deprived of his freedom for 6 years. Now, why do you call one a crime and not the other one a crime?
Well, that's a pretty good question, isn't it? Abe Fortas over here. It's like, hey, we can't help noticing. Like Abe Fortas is like, can't help noticing that if this were an adult, this adult would have, gotten a lot of things. He would have gotten an exact charging document. He would have had the right to an attorney. He would have had due process. He would have had the right to not incriminate himself. There could have been an appeal. There would have been transcripts. There would have been notice, burden of proof, guilt beyond a reasonable doubt, the right to confront witnesses. And after all that, if he's still found guilty, he'd only get 2 months. And this boy gets none of those things. And how about 6 years? So, why do you call one crime and not another? That's a good question. That's a good question, Abe. It's a pretty good question, Abe. I'm feeling you over here. Like, yeah, that's a good question. What you got for us?
Well, I'm not calling one a crime and not the other crime. I'm just saying that under our concept of the treatment of juveniles, all the 50 the legislators in all the 50 states have said transgressions which would otherwise be misdemeanors or felonies if committed by adults are not crimes, and therefore this special treatment is given to them because actually, Mr. Justice Fortas, that the mere fact that this boy was brought in for this particular thing, even though he was on probation, does not in and of itself say that he's going to be sent away. You see, as I see it, there's three steps in the juvenile court proceedings. There's the intake proceeding, the adjudication hearing as to whether or not he really is a delinquent, and then the next one.
One of the questions here is very simply put. If this boy was sent away for the three incidents that have been here mentioned, the baseball glove incident, whatever that was, the pocketbook incident, whatever that was, and the present incident, what is there in juvenile court theory or philosophy? What is there in the theory of the juvenile court which makes it undesirable or impossible for this boy to have had the basic elements of a trial with respect to those incidents, so that at least he would have known, and we would know, reviewing courts would know exactly what these incidents were, what happened, why this boy was sent away for 6 years. Now, is it your position that doing that would destroy the juvenile court theory?
Oh, decidedly not. I don't think there's anything in this case or any other case which would prohibit that. I think we have to, as a matter of fact, I don't believe the Arizona statutes prohibit those things. I know in my own state, you're entitled to counsel, you're entitled to hearing. If you want a transcript, you can ask the court to take a transcript. You see, I don't think anybody questions, any of the three of us, that juveniles are not entitled to the full measure of due process. Again, it's within the area of the specialized treatment as to what amounts to due process in relation to what is best for this youngster. No, I think all courts and all of us here would say that due process certainly should be accorded to juveniles. I mean, it isn't only in criminal cases. No, I don't believe so. Oh, no, I don't believe so. I accept that, I don't know, no, due process. I think due process is essential fairness for anybody and everybody. Now, what due process under certain circumstances may be different. Well, I don't think you can say as a hard and fast rule that due process is this in every case.
Well, Mr. Green, you don't say, do you, that due process is what the juvenile court judge says it is in the particular case, period, and that's the end of the definition?
No, I don't think so.
So, well, do you say that...
I think those are always subject to scrutiny. That's why we're here.
What does it include, then? I mean, if you say it's not something more than what the juvenile court judge decides in the particular case, would it include a notice in writing?
I think adequate notice. Adequate notice, yes.
Would it include counsel?
I think yes.
Would it include warning about the privilege of self-incrimination? Privilege against self-incrimination.
Well, constitutional protections against those things apply in where a person is charged with a crime. Now, again, if we're going to do all those things in the concept of the cases I have mentioned that apply to adults, then we're going to have to say that delinquency is just another name for crimes, and that is, in fact, is not, they are crimes, and then, therefore, all the constitutional guarantees should apply in every respect that you have mentioned here today, and it was outlined in the Kent, for instance, where you declined, at that time, I believe the court declined to accept the invitation.
Well, I don't get anywhere by trying to solve this problem in terms of the use of a word like crime or not crime. I mean, the question is, But we're dealing with here, we're dealing with with proceedings here in which persons may be deprived of their liberty and put in a place for 24 hours a day. They're in custody. You can call it a crime or you can call it a horse, but it's still deprived of liberty.
Yeah, but children are not adults. I think we recognize in this society that there are certain restraints, certain that must be on children, and that some children, by reason of certain circumstances, require restraints, guidance, training over and beyond the natural that they get within the natural custody of their family. Now, the family certainly isn't the natural custodian of their children. And I think maybe that's where we get in a matter of semantics here as to what is the difference. Well, there is a difference between adults and children.
Well, I think there is a difference. Just there's a difference between a man and a woman.
Ooh, Abe's gonna get canceled. Abe Fortas getting canceled. 1966. Abe Fortas says there's a difference between man and woman. Oh, Supreme Court. Oh, Abe Fortas getting canceled over here. Respect.
Mr. Green, let me just ask you one more and then I'll leave you alone. How about confrontation? Would you consider that the right of confrontation as part of due process for juveniles?
If the act is denied by the juvenile, most assuredly. But I would say that a child the court may, in determining whether or not delinquency is present in a certain case, can take the statement of the child, whether he gave it to him in court or to a policeman or something like that.
Mr. Green, is there a National Association of Juvenile Court Judges?
Yes, there is, Your Honor.
Do they agree with you in your position here?
Well, I can't speak for them, and they were asked to come in amicus, but because of the power structure, the organizational structure, they couldn't get together the permission to file an application.
Wow, that's such a thing. Oh my God, can you believe that? There's a National Association of Juvenile Court Judges, and because of their internal bickering, they couldn't get it together to file an amicus brief before the U.S. Supreme Court. That's hilarious. That is just hilarious. They're so bickering amongst each other, they couldn't get together to file an amicus in this case. Good times. Who is this guy with? He's from some society in Ohio. I forget exactly who he is, but he's a third party that they agreed to spend time with. So this guy is a lawyer for some sort of juvenile court judge society in Ohio that, for some reason one of the parties agreed to split time with. So yeah, okay, whatever.
Well, do they all agree anyway?
Sir?
Do they all agree?
As to
any of this, or either way? Either way.
Do they?
He's not representing the National Association. He's representing some sort of Ohio association. So yeah, he's representing some Ohio state-specific thing, not the National Association. So,
all agree? Well, there may be some who agree that some of these guarantees should not extend as freely as I say that they should be extended, or as just Mr. Justice Brooks.
Don't some members of that association take the view that none of them should?
That none of them? Well, I can't say. I don't know, because I don't know all the members of the association. I wouldn't have any way of knowing that.
You wouldn't expect the judges all to agree on anything.
No, that's right. I think they agree that this treatment of juveniles is really different than the treatment of adult criminals.
Mr. Dorson?
I shall be very brief, Mr. Chief Justice and members of the court. On your two questions earlier, the request for Mrs. Cook came at the second hearing, and that's at pages 35 and 36 of the record. With respect to the discretion of the juvenile judge to appoint counsel, it seems to me, if there's any meaning in parents patriae, this seems to me the perfect case where that exercise where that discretion should have been exercised. The record is literally teeming with unresolved issues, and I can't understand why the discretion wasn't exercised.
Who speaks for the juvenile in this respect? Mr. Dorson, do you contend? In respect to counsel, let's assume there's an advice to the child that you have the right to counsel. He looks to his father, and his father says, we don't want counsel.
If the child wants counsel, it's his right that he should have counsel.
Well, he speaks to so the judge shouldn't take the father's word for it.
Well, the question would be under cases like Carnley and Cochran whether there was a knowing waiver of a right.
Well,
I would be very.
How can a child waive the right?
Well, that's the point I was just going to make. I have great difficulty in
so
seeing
you really
how the child
is that in every single case that there necessarily must be counsel for the juvenile, even if the parent is represented.
No, I would not go that far necessarily.
How do you get out of it? How do you get out of it? There has to be counsel.
Well, the counsel
he waives it and he can't waive it.
In certain situations, I think that the counsel probably could represent both interests. Where there was no indication, for example, that.
Well, that's different. You're saying he's represented. He can represent both parent and child. Well, I agree with that. He could represent them both, but you would have to make sure that the child is represented.
That's right. That's correct.
And that there have to be a lawyer in the courtroom. Some lawyers have to be in the courtroom every time there is a determination.
That would be my position, Mr. Justice White. I might add that, as the discretion in this case was not reviewable, and as Mr. Justice Douglas said in the Wunderlich case, absolute discretion is a ruthless master. It is more destructive of freedom than any of man's other inventions. And I think that quote is quite apposite to this situation.
Yes.
Third, on the Fifth Amendment point, we'll rest on our brief. We believe and we suggest that there is a clear case of possible self-incrimination under the Arizona Code. I might add, since Mr. Justice Brennan raised the Illinois situation, that though Illinois was the first state to pass legislatively provisions for a juvenile court, it now provides for 2 hearings, as I suggested New York does, one a fact-finding hearing and another a dispositional hearing. No, it does not. Finally, I want to deal with this question of Gerald Gault's alleged admissions. I want to be as clear as I possibly can on what happened. There were 4 witnesses at the habeas corpus hearing. The first witness was Mrs. Gault. She said specifically that there was no admission of the dirty words at the first hearing, and that's on the record at page 30. She did not testify regarding the second hearing. Mr. Gault was the second witness. He did not testify regarding the first hearing because he was not present. Regarding the second hearing, he denied that Gerald Gault admitted saying the dirty words, and that's at page 24 of the record.
I love how they're just called the dirty words. They are so dirty, they can't be mentioned. This is hilarious to me. I just love how these words are apparently so dirty that they can't be mentioned in open court. Apparently, "Are your cherries ripe?" is so beyond the pale. It is so incredibly prurient that heaven forbid one of these attorneys actually say it in open court. Wow. I think that's hilarious. "Are your cherries ripe?" apparently is beyond all decency. Woof.
There was no admission of the language during the custodial stage of the matter.
During when?
The custodial, the preliminary stage before the hearing, when he was picking up Gerald Gault. He said that Gerald did not admit making the statements. Regarding the first hearing, he said that there was an admission, inconsistently with Mrs. Gault. Regarding the second hearing, he said that there was no admission. Judge McGee was the final witness. He said as to both juvenile hearings that there was a partial admission of language at both hearings. And those are at pages 58, 59, and 61. Judge McGee also testified at page 59 and 70 of the record that he was not satisfied with what had happened at the first hearing. It doesn't sound to me as if Gerald Gault specifically admitted making those statements.
Did Gerald
he did not testify at the habeas corpus hearing.
But did he at the second hearing?
Yes. And the conflict was over what he said, as the Supreme Court of Arizona said. Thank you very much.
Thank you.
All right, so that's it, guys. That's all she wrote for this hearing. And perhaps unsurprisingly, it was 8-1. That this is some bullshit. Which so that was It will only be 5 years till Cohen versus California. That's funny. Fuck the police, or was it fuck the draft? In Cohen versus California, it's fuck the draft, wasn't it? Was it fuck the police? I forget. It was one of the two written on the back of his leather shirt. Wow. So yeah. Good shit, man. Good shit. Fuck the draft? Okay, yeah. I don't remember if it was fuck the police or fuck the draft. Cohen wore a leather jacket that said fuck the draft on the back of it. I think he wore it into a courthouse. And he was prosecuted, and that was Cohen versus California. Yeah, that's good shit, man. 6 years. 6 years for saying, "Are your cherries ripe?" Hey, baby, are your cherries ripe? I'm not even sure I understand exactly what that means. I suppose it's referring to the nipples of the breast, I guess, because they can be cherry red. I guess that's what it means. It's a breast thing, I guess. I don't know, because it's cherries plural, right? So I'm assuming. Okay, I don't know. Who dissented? We could look it up. We could look up the opinion. Let's see who dissented. Let's see. Someone write a dissent. I'm looking. Let me just Google the word dissent. How do I spell dissent? Mr. Harlan. Justice Harlan disagreed. Justice Harlan. At least in part. Dissented in part. Do you dissent in full or dissent only in part? And then what would be the nature of the dissent? Mr. Justice Stewart. Potter Stewart disagreed. Potter Stewart. Whoa. Potter Stewart disagreed. Okay, that's interesting. Should we read what Potter Stewart had to say about this thing? Ovaries? I guess. Are your cherries ripe referring to your ovaries? Okay, maybe. Potter Stewart, baby. Potter Stewart disagrees. The court today uses an obscure Arizona case as a vehicle to impose upon thousands of juvenile courts throughout the nation restrictions the Constitution made applicable to adversary criminal trials. I believe the court's decision is wholly unsound as a matter of constitutional law and sadly unwise as a matter of judicial policy. Juvenile proceedings are not criminal trials. They are not civil trials. They are simply not adversary proceedings. Okay. Well, that's an interesting idea. Juvenile proceedings are not adversary. Okay. Well, all right. That's an idea. Okay. They are not adversary. When treating with a delinquent child, a neglected child, a defective child, or a dependent child, a juvenile's proceedings' whole purpose and mission is the very opposite of the mission and purpose of prosecution in criminal court. The object of one is the correction of a condition. The object of other is conviction and punishment for a criminal act. In the last 70 years, Many dedicated men and women have devoted their professional lives to the enlightened task of bringing us out of the dark world of Charles Dickens in meeting our responsibilities to children in our society. The result has been the creation in this century of a system of juvenile family courts in each of the 50 states. There can be no denying that in the system of juvenile and family courts, there can be no denying that in many areas, the performance of these agencies has fallen disappointingly short of hopes and the dreams of the courageous pioneers who first conceived them. Wow, the juvenile justice system hasn't been doing so great in 1967. It's nice that we were able to fix all that, and now the juvenile system is just fantastic and wonderful and not a problem in any way. Okay. For a variety of reasons, the reality has sometimes not even approached the ideal, and much remains to be accomplished in the administration of public, juvenile, and family agencies, in personnel planning and financing, and perhaps the formulation of wholly new approaches. I possess neither the special expertise nor expert knowledge to predict with any certainty what might lie for the brightest hope in progressing and dealing with serious problems of juvenile delinquency. But I'm certain the answer does not lie in this court's opinion in this case, which serves to convert juvenile proceedings into criminal prosecutions. Okay. Okay. The inflexible restrictions that the Constitution made so widely applicable to adversary criminal trials have no inevitable place in the proceedings of these public social agencies known as juvenile or family courts. Okay. And to impose the court's long catalog of requirements upon juvenile proceedings in every area of the country is to invite a long step backwards into the 19th century. In that era, there were no juvenile proceedings, and a child was tried in a conventional criminal court with all the trappings of a conventional criminal trial. So it was that a 12-year-old boy named James Guild was tried in New Jersey for killing Catherine Beeks. A jury found him guilty of murder and was sentenced to death by hanging. The sentence was executed. It was all very constitutional. Well, for whatever can be said for executing a 12-year-old boy for murder, at least, there was due process involved, such as it was. So, yeah. A state in all of its dealings must, of course, afford every person due process of law. And due process may require that some of the same restrictions which the Constitution has placed upon criminal trials must be imposed upon juvenile proceedings. For example, I suppose that all would agree that a brutally coerced confession could not be constitutionally considered in a juvenile court hearing. But why not, though? Because it's not adversarial. But it surely does not follow that testimonial privilege against self-incrimination is applicable in all judicial proceedings. Similarly, due process clearly requires timely notice of purpose and scope of any proceeding affecting relationship of parent and child, but it certainly does not follow that notice of a juvenile hearing must be framed with all the technical niceties of a criminal indictment. Well, that's nice. That's a nice way to be pretty dismissive, Justice Potter Stewart, man. Wow. Niceties of a criminal trial. Wow. The way Justice Potter Stewart tells the tale, it's just that they didn't follow quite the Queen's English in minding their P's and Q's. Justice Potter Stewart over here is treating this like, these are some minor defects that are barely worth noticing. Oh, they misplaced the comma, in their indictment. Oh, okay. I think we can all figure out what they meant, though, right? So sorry about the misplaced comma. Also sorry about your lack of due process. These are not quite in the same category, man. In any event, there's no reason to deal with issues in the present case. The Supreme Court of Arizona has found parents of Gault knew their rights of counsel to subpoena and cross-examine witnesses, of the right to confront witnesses, and possible consequences of finding delinquency. It further found that Mrs. Gault knew the exact nature of the charges against Gerald from the day he was taken to the detention home. And as Mr. White correctly points out, no issue of compulsory self-incrimination is present in this case. I would dismiss this appeal. Wow. Wow. Yeah. I like this. This is some good shit, man. This is good shit, man. Wow. Potter Stewart, man. Potter Stewart. Potter Stewart. Nominated by Eisenhower. He served as a justice from 1958 to 1981. Died in 1985. Republican. Nominated by Eisenhower. That's interesting. That's cool. Yale Law Student, served in World War II as a member of the United States Navy Reserve. Practiced law and served on Cincinnati City Council. Court of Appeals for Sixth Circuit. He emerged as the centrist vote on the Spurger Court. Of course, famously said, "I know it when I see it," with respect to what obscenity was. That was him. What a guy. Potter Stewart. What a great name, man. What a great name. Yeah, what a great name. The best name, though, the best name of a judge who never made it to the Supreme Court. And the reason he didn't is interesting too, and sort of like the politics of the thing. But the best name of a judge still has to be, all time, it has to be Judge Learned Hand. What a great name. What a great name. U.S. District Court for the Southern District of New York and U.S. Court of Appeals for the Second Circuit. Often talked about as a potential nominee to the U.S. Supreme Court. He wrote some very interesting decisions that are still studied in law school today. He is definitely a very interesting guy and wrote some very interesting decisions. So even though he didn't make the Supreme Court, he was very influential in his own right. So he's one of those Court of Appeals judges that sort of kicked above his weight. You know, it's one of those Court of Appeals judges that kicked above his weight. So, and I think he just has a great name. I mean, how can you not love this guy's photo? Look at this guy. That's Learned Hand, man. Kick ass. Yeah. So he wrote some interesting decisions. Yeah. And then it notes here in Wikipedia, Hand authored approximately 4,000 judicial opinions. Admired for their clarity and analytical precision, they've been quoted more often in Supreme Court opinions and legal scholars than those of any other lower court judge. So he definitely kicked above his weight. You know, he kicked above his weight. He was also a founding member of the American Law Institute, which helped to develop the restatements of law that has been used as the basis of like most of the modern statutory law. Yeah. So definitely a very influential guy. So Learned Hand was his name. Learned Hand was the guy's name. Bill Learned Hand, who went by his middle name. Billings Learned Hand went by his middle name, Learned. His parents literally gave him the middle name Learned. I suppose he was. Yeah. So there you go. So never quite made it to the U.S. Supreme Court, but definitely in his own right. So, yeah. So you don't diss Learned Hand. I mean, he's quoted a lot more than a lot of Supreme Court judges, to be quite honest. You know? So, I mean, he's up there in that pantheon. You know, not every Supreme Court justice is quoted, equally well. I mean, he's definitely more well remembered today than the last Supreme Court justices, even though he's been dead for like 100 years. So, he was probably more influential than the last Supreme Court justices. So, he didn't do too bad for himself. So, yeah. Well, my friends, I'm going to sign off for now. I'm going to go to the gym because I need to get my swole on and go from there. I've been on Civil Law. Until later, my friends. And let me know if you like this stream. It wasn't very popular. It wasn't particularly well liked or anything. But, if there's a lot of interest in this kind of thing, if we see a lot of interest in doing historical stuff, we could do some historical stuff. So, I thought it was fun, and we can do some deep dive, and we could go back to the 1950s and listen to some old school oral arguments, and all that stuff. All right, I've been on Civil Law. Until later, my friends. I hope all's well. Cheers, my friends, and goodbye.